Yes.
And then may I mention one writ petitions for tomorrow, my lord. For tomorrow.
Writ petition should be there for number one.
My lord, in fact, my lord, they consulted the registry. Then my lord, they suggesting for the my lord, the mentioning before your lordship. My lord, from the registry, my lord, it is suggested that mention is to be made before your lordship for my lord, listing of the matter tomorrow, my lord.
If the court number one doesn't agree, you come. We'll give you liberty.
My lord, as per the suggestion of the my lord,
It's not a registry.
My lord.
He has registry is
my
wrongly
lord, my lord,
suggested.
writ petition are placed before both the courts, my lord. That is the reason.
You make a mention because propriety.
My lord,
You make a mention. If she doesn't agree, you come.
my lord. Develop.
And it will be listed if you have
My
filed
lord,
today.
listed, my
It will
lord.
be listed tomorrow only.
Yes, my lord.
You make a mention. Otherwise, if you have already filed, it will be listed
My
tomorrow.
lord, it will be listed
Either-
as per the my
Letter
lord.
of the court. You tried it.
Yes, my lord.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 37 of supplementary hearing, Your Lordship.
37.
Yes, Your Lordship. I beg to pray for adjournment of this matter after 2 weeks, Your Lordship.
What is the matter here?
Lordship, this is a service matter, Your Lordship.
37.
Yes, Your Lordship.
What service matter?
Lordship, this is land matter. Lordship.
Land matter is
Land
not
matter?
37.
Yes, Lordship. This is land matter. Lordship.
You are claiming for damage of
sir.
your boundary one.
Not only boundary wall, Lordship. Land is claimed by the government, Lordship.
Okay.
And I am claimed land is a private land.
Okay. Before the town is still yet to
Yes,
the
not
land
right,
for
Lordship.
Yingkiong town is under process of acquisition.
Yes, Lordship. Not acquire.
We'll dismiss it.
Your Lordship,
We'll dismiss it.
Your Lordship, after a week, Your Lordship.
No.
At least, Your
We'll
Lordship.
take it up. What's there?
Lordship.
It's within Yingkiong town.
Not Inkyong town, Lordship. Outside the Inkyong town, Lordship.
So you are claiming that
Yes, yes.
the
Land
land
is
petition
outside.
doesn't lie. You file a title suit.
Lordship, here is the case, Lordship. They
We'll
accept,
see.
Lordship.
We'll see.
Your Lordship,
I may not require to hear you. We'll hear the
Yes, Lordship.
petition.
Lordship, Lordship, after this, Lordship, on time, Lordship.
What time?
Lordship, it's my senior will appear, Lordship.
We'll take it up today.
Okay, Lordship.
Don't worry.
He's ready, Lordship.
You go through the file.
obliged,
If
Your
it's if you are claiming that it's a private land and government is claiming that it's a government land,
Yes, Lordship.
you file a title suit. That's all.
Yes, Lordship.
You'll dismiss.
Yes, Lordship.
Your, I may not.
My
This
senior
court
will-
may not require your senior also.
Yes, Lordship. My senior will-
You appeared.
Okay.
Yes.
May I please, my lord? My lord, I beg to mention item number 8, 9, and 13.
8, 9, and 10.
Yes. My lord, due to
Yes.
some urgent emergency, senior counsel is out of station. And we have informed all the respondent.
8, 9, and 10.
13.
8, 9, and 13. Separate orders. But 8 and 9 same orders, huh? Who? Mr. Ozing Opada.
Yes, opener.
On the prayer of Mr.
H. Takum.
So and so learned counsel appearing on behalf of Mr. Opada. List this matter after 4 weeks,
My lord, it may be listed after day after
weeks.
tomorrow.
3 weeks.
My lord, day after tomorrow. On
Why? Next week. After
obligement.
13 also.
Yeah, please, Your Lordship.
Yes.
I think to mention item number 36, Your Lordship.
36.
Yes, Your Lordship. Here, Your Lordship, affidavit,
You withdraw.
Lordship,
You have not joined. You were appointed for 6 months on
Lordship,
contract basis.
yes.
After the expiry, you have joined. What is this?
No, Lordship, but during the, it was a COVID period.
And you have misled that you have not you have not been received of your pension.
No. This is not absolutely not regarding pension.
You have made a statement
No,
saying
I
that
said that
you
I
are
have,
yet to receive the pension.
no. I said that I have,
Sir, we'll take it up. Nothing is there.
Lordship, can it be next week? Lordship?
No, today.
Lordship, I have to file one affidavit in reply because,
Nothing. You were appointed on contract basis as a
Yes.
consultant
yes,
for 6 months.
6 months, yes.
You have submitted your joining report after the expiry of 6 months.
Lordship, during the COVID
Taking the
period,
COVID.
it was a COVID period. I was not been allowed to enter. So during that period, I have worked one, Eki Dubey's pension case, which I have,
We'll hear you today.
Worship, can it be next week, Your
No,
Worship, because
today.
otherwise.
You be here, we'll take it up. Till 4:45, there's
I
nothing,
replied because they said that I have not.
there's no
worked.
question of reply. Your own showing, you have you have submitted, after 6 months.
But during that period,
Be happy, you are a retired man, enjoyed a retired life. If you are not getting pension,
no, this is absolutely. not regarding that.
retirement benefits, if you are not getting, we'll immediately direct them
No,
to
this is,
pay.
I have not claimed
Pay.
any pensions.
If you are not claiming, if you are claiming for the salaries
6
which
months.
you have not worked, nothing.
Lordship, there is no records to show that they have,
I
he has
have-
joined the
I
work.
have
We'll
been
take it up.
provided- I
Yes.
have been provided some documents, Your Worship. So I wanted to annex that and want to file a
No,
report
I have gone through it.
for that. only.
We'll take it up today.
Your Lordship, I beg to mention item number 32, 33, and 34. It's analogous matter.
Why?
Actually arguing counsels from the Assam, so he's,
With Assam,
yes.
Mr. Sunil Mao is there. Esmo is there. Where is Esmo? What is the matter? Yes,
Well, this matter, senior Majumdar sir is appearing this.
what is this?
It's a matter related to BFR, village forest.
Nothing. Village forest.
Reserve
Reserve.
areas.
Whether
Which
we'll-
was
whether
illegal.
We'll see, we'll direct them to go as per the rules and the act, regulations.
Which was illegally,
As per your claim, we'll direct them to go as per and make a reserve forest.
no,
That's all.
villagers, in this case. Villagers.
See, what is the reason for constitution of village reserve forest?
Well, there was no reason, in fact, some of the forest.
I think
officers-
you have some misconception, the
But
petition.
there was some mislead by some of the
See.
villagers.
The land ownership will remain. It is only for conservation of the, environment and forest. That's all.
But that is,
You are saying that there is a violation of the regulation, we'll direct them to go follow the regulation and have that reserve forest, village forest, you know that. That's all.
then Malad, maybe taken to more Malad. Maybe taken up to more level.
Why?
Because I have not gone through the file and let me
I
talk
have
to,
gone through, don't worry.
let me talk to
I'll
the
assist you.
senior counsel.
Okay. On the prayer of Mr. Esmo, learned counsel for the petitioner, list these matters tomorrow. 31st 07/20.
May I please?
Yes,
Lordship, I beg to mention one phrase I can civil state tomorrow from that motion.
read petition.
No, civil division.
May I, Your Honor? And I'd like to mention item number 31 on behalf of K. Tagyang.
Which
Item number 31
31?
on behalf of K. Tagyang. Your Honor, the council is out of session.
We'll see, it's order stage, what is to be done here. We'll see, you be there. What is to be done here? Let's see,
Your Lordship,
31,
we are filing our affidavit today itself, Your Lordship.
you're
In-
filing,
Yes, Your Lordship.
okay. Mr.
H. Tai.
Ah,
H. Tai.
London Council appear on behalf of Mr.
K.
K.
Tagyang.
Taja, London Council for the petitioner. Praise for adjournment of the matter on the ground that his senior Mr. K. Taja is the disposed to take. Expert, Mr. White, London State Council. Has also submitted, has also prayed for listing the matter. After 2 weeks.
Your Lordship,
So
after
it's
a week,
whenever-
Your Lordship,
Huh?
after a week, Your Lordship, there is
After
an
a week,
interim, Your Lordship.
After weeks.
Interim may be
Whenever
continued.
came to file an affidavit in the opposition. Having considered the submissions of the land council to list this matter after 2 weeks.
Your Honor,
In the
interim may be
meantime,
continued.
The state may file their response. Yes.
Obliged.
Obliged. Your Honor, interim
weeks.
may be continued, Your Honor.
Interim order plus earlier circuit.
Obliged.
My lord, if I may. My lord, I beg to mention item number 2, lordship.
Item 2. Withdraw.
No, lordship. Actually, lordship, two bail
482.
applications arising out of the same
438.
affair.
Huh?
One was listed before code number 1 and one was listed before my lord.
Ah.
So a mention was made before code number 1. My lord had directed that this is sending the matter here for consideration, my lord.
Why?
My lord, it is a similar matter arising out of the same affair.
No, when did you file this bail application? Item 2.
Yeah, yesterday.
After 1st of July.
After first.
Why 438?
Lordship,
It should be 482.
lordship, it was a pending case registered way
No,
before.
there's a misconception. Register will consider the sections of the IPC,
Yes, lordship.
not the bail application.
Lordship, in this regard, there is a judgment recently passed,
I
ordered.
have seen it. Don't worry. You file it.
Yes,
Now you have to file
lordship.
under the new act. Withdraw it and file fresh.
Lordship, can I be given liberty to amend
Mr.
it?
So and so. No. Learn counsel for the petitioner.
Petition.
Press for withdrawal of the bail application. As well as bail application number
108, lordship. 2024.
108. To withdraw and file a fresh.
Lordship.
In
Lordship,
view of the defect in it.
Your lordship, sorry, but your lordship, that issue was raised before the coordinate bench, your lordship, regarding whether.
I beg to differ. I'll pass the appropriate order in that case.
Yes, your lordship, that may
We'll
be.
consider the offense under the old act,
Yes, your lordship.
but the application has to be filed in the new act.
Your lordship, that is need to be discussed before your lordship, because the judgment of this honorable court is there in Sanjit Kar versus State of AP, your lordship, which in this that issue has been considered because of the saving clause of 531 of the.
That I've seen. That's
Yes.
why I don't agree. This is with regard to the offense,
Yes, your lordship.
not the application.
Of your lordship, it's regarding the pendency, your lordship. If it
Yes,
was
it-
pending, investigation is pending, your lordship. The word used in the saving clauses, your lordship, that has to be looked into because it says the pendency of the appeal, inquiry, or investigation, your lordship. It also included the investigation, your lordship. And it says until it is disposed of or it will continue.
That's why I'm saying investigation will take the all provisions and the offense. The application has to be filed in the new act.
And your lordship, again in the saving clause, it says, you speak about the, your lordship, the governing the, your lordship, limitation period, your lordship. The new BNSS will not be enabled for your lordship, condone the delay, which if there is any FIR, meaning that has all the aspect has to be
If you
taken.
have you are also having objection.
Yes,
We'll
lord.
decide it tomorrow. List this matter. List this matter. Bail application. Item 2, huh? Tomorrow. I'll consider it.
But your lordship, this is the SIT matter, your lordship.
Huh?
SIT matter, since this matter was settled by this court, for that I'm apprising your lordship. Otherwise,
So I will decide. I may, prime facie, I don't agree that. So
Yes.
far as the application is concerned.
yes, your lordship.
We'll send it to,
Lordship,
Yes,
there
we'll
is a-
see, I may agree also. Prime facie, I think, as of now, I don't agree.
Yes, your lordship.
Lordship, a small prayer if it could be
Yes.
considered. Lordship, there is a medical emergency. Can it be listed on Thursday, Lordship?
Thursday,
There is a
Not
medical
tomorrow.
issue tomorrow, Lordship.
not tomorrow.
Thursday.
Okay, Thursday. Both the,
The board.
the list this matter on the prayer of learned counsel for the petitioner, list the applicant, list this matter along with AB 108 of 2024 on
Thursday,
Thursdays,
Lordship. 1st of August, Lordship.
first of August, 08.
Much obliged, Lordship.
May I please, Lordship?
Yes,
Lordship, I beg to mention item number 35. I'm on behalf of Mr. K. Tari, leading counsel for the petitioner. He is currently out of station, Your Lordship. Therefore, this matter may be adjourned for the day.
what is the matter?
Yes, Lordship.
What is the matter?
Lordship, actually, I doesn't have the brief. I have been only instructed to
What
take
is
down.
there unnecessary? Now you are out on bail. Now you are out on bail.
I doesn't have done the brief.
It's basically a writ petition. It's basically a contempt petition. contempt petition camouflage as writ petition. Yes, Mr. PP. Where is it? Who is appearing in this matter? Item 35. There is a writ petition. Who is appearing in item 35?
Your Lordship, senior government advocate,
Where is?
Tapin sir is appearing in this matter.
Ah. We'll see. You be there. You be there. We'll see.
Lordship, the leading counsel is out of station. Leading counsel is out of station.
You take the advantage. Give him the file. File. Read the file.
Yes, sir.
Tell him. We'll take it up.
Obliged.
May I please, Lordship?
Yes.
Lordship, on behalf of the Majumdar Lordship, I beg to mention item number 5 and 6, Lordship.
5 and 6.
Lordship. Lordship, this matter may be listed on 8th of August, Lordship.
5 and 6. And it 5, 6, and 7.
Lordship.
Yes, Mr. Pangi.
My lord, the writ petition I represent, my lord, is subject to what is been decided in the other case. In fact, my lord,
Who is appearing in this?
Lordship conducted counsel, he is the Majumdar Lordship. He is
Yes.
what Lordship.
Okay. So
Yes,
one to
no.
one.
So, Lordship, matter may be listed on 8, Lordship.
This is 2014 matter.
Lordship. Lordship, he could not be available today, Lordship.
On the prayer of Mr.
K. Tabang, Lordship.
K. Tava, learned counsel appearing on behalf of Mr. D. Majumdar, learned senior counsel for it. For the petitioner in writ petition 259 of 2014. List this matter on 08/08/2024, along with item 7 and 8. I mean 6 and 7.
Daily, Lordship.
It's not settled, well, it's regarding seniority.
Seniority, my lord.
It has not been settled.
my
It
case
has-
is in fact meaningless now. It will depend on what will be decided in the first case.
In fact, there's an issue of delay in lectures also. This
No,
was
but
senior-
once they have gone 2-3 steps
That
ahead.
part I have absolutely no idea. That has been, they have been raised in the other writ petition itself.
You find it out. I think.
I'm not representing,
Yes, why?
they have, I mean, in fact, very peculiar situation. My briefs would have been taken back, in fact. That has also not been done. I'm just,
my lord, time-bound promotion, 2 time-bound promotion has been done.
Yeah.
Thereafter only, after almost 10 years, my lord, they have approached, my lord.
What would have any,
My lord,
will it have any bearing
my lord,
in India's service career?
my lord, almost most of their, my lord, they are, wherever they are happy, my lord. They are, most of them are at the verge
So
of
that's why I'm
retirement,
asking, if suppose it is settled today
my lord.
about the seniority, it will have any bearing?
My lord, I don't think so.
You don't get any either benefits of financial benefits or because you have crossed.
Already crossed, my lord.
One up to 2-3 steps.
my,
Seniority is basically for what?
my case,
promotion,
was-
my lord.
my case was for something totally different.
Now,
The other issue, I have absolutely no idea. Man.
Well, this item number 5, basically the challenge was the respondent was a GDMO along with us. Then he opted for the specialized cadre in terms of Arunachal.
no,
Pradesh
that's what I'm
Health
saying. It's a regarding
Now,
seniority
Yeah,
only.
yes.
Seniority only.
Then my
Now
lord,
you have been promoted twice, thrice. I mean,
yeah,
2-3
yeah.
steps.
But thereafter what had happened, he has
Suppose
opted.
today, if we all that you are senior to them, what benefit you will get?
Nothing.
Then
That's why I'm just trying to.
it will be a futile.
Well, that's why I'm trying to clarify. So
Let us
The-
dismiss.
no. What had happened is, then the private respondents.
We'll record the judgment of the Supreme Court. No
Item
futile
number
writs.
6.
No
in fact, is-
futile writs.
Pardon, my lord?
No futile writ is permitted to be issued.
A Trilok Singh judgment is a 1969.
Tilak Singh.
No, Trilok Chand, 1969, Milord. One SEC, Milord. Page number I don't remember, but I remember the part. If it is to be a fetal
This is in fact, I understand infructuous, because praying for DMO now, he is director in the age control.
Yes.
6 is infructuous, I think.
Six instructions.
Must be,
Will dismiss on instructions. I mean.
but I have
this
no
was-
instructions, my lord. They are fighting it out. Item number 5. Let them, my lord, whatever.
So
is
Mr.
decided there-
Majumdar is appearing in item 5. You are in 6.
Yes, I am.
You take instruction.
I will.
Okay, on 8. On 8. Tell your senior also that it is the, I mean, tentative view of the court that even if your prayer is allowed, treating you be a senior on and settle as per your if your grievance is
able to tell, yeah.
prayer
Tell
is
the
allowed
parties to
also,
be
what
able to tell. What could be the
benefit you will get
consequences like that?
today? 24, 16, 15,
I will inform
16
Mr. Jamo.
yes.
Mr. Jamo is engaging Mr. Modi.
Yes.
I will inform.
Actually, the issue was very simple in this case. So, he has got a specialized cadre. Again, he has come back.
Why in the futile read, Mr. D. Majumdar has been engaged? Why not? Why
I'm
you
for the petitioner.
Mr. Majumdar is for?
Item 5. Because, this futile writ will not come into play because there is a continuous civil wrong. And once the action of the administration have a consequences and continuous civil wrong,
No,
infringing
Mr.
upon the
Majumdar,
rights.
are you appearing in item 5?
Yes, yes. I'm for
And
the
Mr. Majumdar for whom?
the private respondent.
Private respondent. Okay. Then you read Mr. D. Majumdar. I thought it's for petitioner. Anyway, on 8 we'll see.
8. Which date is it?
8 August.
8 August. 8 August.
No, I was under the impression that Mr. Majumdar is appearing for the petitioner.
No, he is for
Petitioner.
respondent.
That's why I've asked you.
No, 8. I may have to.
You
request
decide.
Sabha to accommodate which date you want. Because 8, I will be out of state. Can it be on 14 below?
You decide.
15th, though it is holiday. You can request Majumdar sir to come. He can also part of our celebration here. 14 below. Every time we accommodate them, they out station
Okay.
advocates.
14.
Yes.
May I, Lordship? Lordship, I beg to mention item number 10.
Yes.
I'm on behalf of B. Taba. Lordship, in this matter, we will be filing an affidavit in reply, so some time may be given.
MS so-and-so, learned counsel appearing for Mr. B. Taba, learned counsel for the petitioner. Press bond is granted 3 weeks time to file affidavit in reply. List after 3 weeks. Yes.
Deeply obliged.
I beg to mention item number 35.
Item
35.
35.
35.
Yes.
This matter will be list after a week. After a week.
No, we'll take it up. We'll see.
This
You be there.
council is out of station.
What is there? You go to it. Who is that lawyer? Young lawyer who has mentioned item 35.
The same item.
Have you given the file? No, item 35, you hand over give the file to them. Second file to them. Tell him, call him, go through the file. I asked him to read the file. Yes. Yes.
Lordship, this is a regular bail, Lordship.
Holford City.
Yeah, for 439, I filed, Lordship.
Yes.
Because Lordship, incident, Lordship, before the BNSS come into force, Lordship. FIR, Lordship, register on 11 for 2024, Lordship.
Yes, then
So, Lordship, at this instance, Lordship, there is no interim prayer, Lordship. At this instance, Lordship, notice may be issued, Lordship.
what is the new section?
New section is, Lordship, new section, Lordship. I forgot to brought, Lordship.
Yes, 439 new section.
Lordship may,
Yes, madam,
Your Lordship may,
481.
Oh, BSS.
Or Mr. G. Bamlan codification. Find out.
yes, Your Lordship may, I have not got the corresponding.
Learned counsel for the applicant. Expert. This is the application for grant of posterior bail to the accused person, namely Sri Nyamar Riang, in connection with LOPS case number 26 of 2024 under section 21 within bracket B, bracket close, /27 capital A of NDPS Act 1985. Who has been arrested on 15/04/2020. Call for the scanned copy of case diary, right?
Yes, Your Lordship.
Case diary. MS. PG, learned additional PP for the state. Yeah, appears for the state. The list, the better after. When?
On 12th of August, Your
On
Lordship.
12/08/2024. The issue as to whether the bail application is to be filed under the provisions of new act, that is IE, BNSS, 2023, or continue to be filed under the old act, that is CRPC 1973. If the FR is registered prior to the coming into force, prior to the coming into force of the new act, that is on 01/07/20 shall be determined on the next date.
Deputy.
I don't know, I have. So according to the
According to Lordship, as.
judgment of the coordinate bench,
Yes, Lordship.
the application has to be continued to be filed in the old act
Yes,
if the
if-
offense or the case is registered
Yes,
or investigation is
Yes.
under the old act, provision of the old act.
yes, Lordship. So
That is,
Lordship,
that is
I
the,
file, Lordship.
that is the view.
Yes, view of the coordinating means, Lordship.
So we'll decide.
Yes, Lordship.
Deputy.
Continuation of the offense and investigation and other thing,
IPC.
I have no doubt. But so far as the filing of the application, after the, I have some doubts,
Some of Supreme
I have
Court,
some reservation.
Lordship, there is contradicting view, Lordship.
Where?
Other High Court, Lordship, there is contradicting view, Lordship.
No, other High Court is also of the same view. I've seen it.
I have seen some.
Delhi High Court also. Delhi High Court, Punjab, Kerala, and this man. Same view.
Same view.
But it is not about filing of the, I think, if I remember correctly, filing of the application after the end. This was maximum is of the continuation of the offense and the investigation.
Your Lordship, if, I don't know if I'm right or wrong, Your Lordship, even Article 20, Your Lordship will see that if anyone, during, at that point of time when the law exists, Your Lordship, he has to be dealt with according to that law. If that is to be taken into consideration also, Your Lordship.
No, it's not a question of Article 20. It's a question of 531.
531 is also there, otherwise
Saving cost.
saving
Artic-
clause is there, but then
Article 20 means what?
of the constitution, your lordship, where it is stated that a person has to be dealt with as per the existing law at that point of time, your lordship. It
No,
also says-
basically, the penal provisions cannot have a retrospective effect.
Yes, that for sure.
That is the essence in Article 20.
Keep your question.
Yeah, your lordship may plate.
Yes.
May I just place one judgment of
Yes, let us
1983? This was a pension matter.
Huh?
It was a pension matter and your honorable court was placed to direct to pay the pension as per the rules in 1971. But the same matter was not implemented. And then the petitioner came back in 1970, up to 1974, after 7 years. And then, may I just read the, from the first page, head notes, may I read only the head notes that will be relevant. In the Devaki Nath Prasad versus Bihar, 1971, supplementary such as directed to that decided on May 4th, 1971. The court had, after coming to the conclusion that petitioner herein was a member of Bihar Education Service entitled to pension under such and such the Bihar pension rules, issued a writ of mandamus directing the state government to consider the claims of the petitioner for the payment of pension according to the law. In spite of the petitioner having approached the chief minister for the implementation of mandamus, still it was not until 1974 that the concerned file raised on the chief ministers and other were passed by him, and petitioner should be deemed to belong to class 1 post of the selection grade from January. This is a fact, 1952, and this claim should be settled within a month. 3 years after this direction of the chief ministers, the petitioner received an intimation that his pension has been computed on the basis of that he has retired from the class 3rd service. Further important is the further representation which was filed. Having failed to evoke any response from the state government, the petitioner approached the court once again. He approached once again. That is when the direction was in 1971, and same was not implemented till 1974. So no contempt was filed. And may I just read the next hell. The respondent states, and all its officials are bound to compute pension of the petitioner not only on the footing that he is a member of Bihar Education Service, but also on the footing he was promoted to class 2nd by the date mentioned in the earlier judgment, and from January 1, 1952 to class 1 as urgently held by the chief minister. Officers dealing with the pension case of the petitioner appears to have scant regards for the decision of the Supreme Court in that both the promotion to class 2nd and further promotion to class 1 from the deemed date were ignored, and pension was computed on the basis of that petitioners retired from class 3rd service. The state cannot be permitted to play in darks and bricks with the solemn decisions of this court. The state and the subordinate officer responsible for the computation of pensions of petitioners are directed to complete. So the fresh direction was given, directed to compute his computation by July 31st, 1983.
When and it said repeated repetition is maintainable.
Malat, here also
It's not on the facts, so this was filed under Article 32.
Yes, but then here also it's
The
also,
issue has not come up. Next.
yes. So,
Not
so
applicable.
in my case, my lord, in my
The
case,
judgment relied by Mr. Esmo, Learned Counsel for the petitioner in Devikanandan Prasad versus State of Bihar. Reported in
AR 1983,
AR 1983,
SSC 1134.
AR 1983 SC.
Yes, Supreme Court 1134.
1134 is not relevant and applicable. Then next,
Well, I have filed a representation also that
you keep on filing. Then next judgment.
only this much, my lord, because
Next
other-
judgment,
no, only this much the judgment I have.
I have held that it's not applicable.
Then my lord, may I pray that let me withdraw my petition and liberty to file a contempt, my lord. Otherwise,
You
if
cannot,
otherwise, my lord, prejudice will be caused to the
What cannot-
petitioner.
create the remedy against the statutory remedy.
Basically, we were supposed to file the contempt, but then we, because of the delay, so we could not file it. So just, you also may pray that I will be, your lordship may allow.
Same prayer shall not be issued direct in respect for payment of land come in respect of the in terms of the judgment and order. On this ground only we are dismissing.
Dismissal, my lord, my prayer will be that dismissal will cause prejudice. So I want to withdraw and the liberty to file contempt.
Contempt now. You cannot
If not
create a remedy contrary to the
then I may be allowed to withdraw. My lord.
withdraw. No liberty.
Yes, liberty to pursue the matter, my lord.
I thought I'll dispose of on merit because Supreme Court says such petitions amounts to abuse of process. 3 days. You have wasted the public's time for 3 days by filing this petition.
My lord, in fact, we are
What
doing-
more abuse of the process
my lord, we were,
than this?
I apologize for that because we were doing some research on that.
It may sound little harsh, but
Yes.
we should not. Hurt Mr. Esmo, learned counsel for the petitioner. After arguing the matter for some, should we record your presence? And also heard Mr. Waidira, learned state counsel,
I'm for three.
Mr. Alseke, learned counsel for respond number 3. Be come to for respond number 3. 4. Respond
Two.
Respond number 2. You just, Mr. Esmo, learned counsel, after arguing the matter at some length. Come on. Fairly. Fairly submits that he may be fairly. No. Come on realizing that the present writ petition would not be maintainable as the main prayer in the writ petition has already been granted in the earlier round of writ proceedings. Being, what is that judgment?
Yes, my lord, judgment. is, my
The
lord.
writ proceeding,
Judgment is in the page
page
30. 30 and judgment dated 0802 to 2023.
that it zero 2020 passed in WPC 35 of 2017. What is this sentence? On realizing. Fairly submissive and faithful will of the present writ petition. Please. Having considered the submissions and the prayer of the land concept of the petition, as well as the order dated so and so, huh? Same order, part but is called in writ petition. The prayer of the learned concept of the petition is accepted. Stuff. Next para, according to the writ petition is stated.
Well, liberty to pursue the matter. That may be also added.
The next para, it is the disposal of the dismissal of the writ petition on withdrawal shall not preclude the petitioner to pursue the matter with the respondent authority in terms of order that is so and so. Lenient.
Obliged.
Sir, any instruction?
Lordship may not take up, my lord.
Why?
Because legal advisor was given by you, my lord, during your as a senior additional advocate general, my lord.
Is it?
Yes, my lord.
Where is it my advice?
It's a part of record, my lord, official record.
Is it? What to do? It should have been listed there.
Some other appropriate bench, my lord.
List this matter before any other appropriate bench without me. Huh? Budget breaking.
You say quashing, joint quashing petition, your lordship.
Yes.
And they have settled the matter. And the section involved is 354, 427, and 323 IPC, your lordship. And the matter is in investigation stage.
Okay.
Sorry, lordship. The settlement has been arrived just after 32 days of lodging the FIR, lordship. FIR was lodged on 19/10/2023, lordship. And settlement was arrived on 20/11/2023. The offense was registered under section 354, 427, and 323.
Yes.
And here only the non-confundable is under 354, lordship. Since both are mutually settled their differences, so on the basis of their settlement, may I humbly pray that matter may be. My lordship may cause the FIR.
Yes.
So since they have settled the matter, your lordship, the state.
What is 354?
Yes, sorry, your lordship.
Yes.
What is 354?
Outrage against woman modesty, your lordship.
Very serious.
Punishment is up to 7 years, perhaps, your lordship. It's a serious offense, but not heinous.
Serious but not heinous.
Yes, your
Not
lordship. Not heinous, your
So
lordship.
you have no objection.
Since they have settled the matter, your lordship.
I have judgment of our own High Court.
Had Mr. K. Lolan, learned counsel for the petitioners, and also had Mr. Theatre, learned addition PP for the state. Next paragraph. By filing this application under section 482 of CRPC, 1973, the petitioners have read for quashing of the read for quashment of the FIR.
Yes, Lord.
What is the FIR number?
FIR Lordship. Case
No,
number 14.
Women PS,
Hello, woman PS case number.
okay.
2020.
No, quashing of the woman PS case number 20 of 2023,
Yes, Lord.
arising out of FIR dated 1910-2023, and section 354, 427, and 323 from our IPC on the basis of settlement between the petitions.
Settlement arrived on 2011. Lord.
Next paragraph. The case has arisen out of an FIR lodged on 1910-2023 by the petition number 1 against the petitioner. Stating that petition number 1 runs a small restaurant as a small restaurant at Nagar, Triple K, the KKK Chartoha building, which is owned by the elder brother of the petition number 2 since many years. It is alleged that taking advantage of being alone, the petition number 2 had always tried to manipulate and ask for allegation is very serious.
This is only Lordship, the allegation made in the FIR.
It's just put para 2, para 2, page 5. No, FIR. Read petition, para 5. Sorry, para 3, page 5. According next para. On receipt of the FIR, women PS case number 2023 was registered under section 354, 427, 323 IPC against the petition number 2. Next paragraph. The learned counsel for the petitioner. No, it is contended that the After 36 days of lodging of the FIR, the petitioners have come to a mutual settlement. As the petitioner number 1 is a tenant and close family relatives of the petitioner number 2. Lister. The settlement was entered into on 20/11/2023. In the presence of Gaburas, public leaders, and elderly members of the village, as the petitioner number 2 has voluntarily agreed to withdraw the FIR lodged against the petitioner number 2, as the FIR was lodged on being IRKE, AD, behavior of the petition number 2, which in fact was not a serious issue. The next paragraph. Mr. K. Leonard, consult with the petitioners, submits that since the petitioners have settled the matter by way of mutual settlement agreement dated 20/11/2023, at the intervention of the elders, family relatives, and including the Gavuras of the area, and also the fact that the petitioner number 2 has not committed an offense, and the allegations and the offense are not serious in nature. The investigation and the investigation of the woman PS case. Women PS case number 20, 20 of 2022. Maybe set a certain request. He submits that since the parties have already settled the matter, the continuation of the investigation will be futile, and in the process of an abuse of the process of the law. Therefore, he submits that the FIR and the allow women is case number so and so, maybe such a certain cost, maybe cost. Next paragraph. Mr. T at the London Council for the London Additional PT submits that is there. Parties have settled the matter between them, and considering that the offense alleged under section 354 is serious but not heinous. 354 IPC is serious but not heinous. Come on. This court may pass an appropriate order considering the nature of the case and the settlement, and may watch the investigation, watch the FIR. Next. Consider the submission of unconstitutional parties and where is the materials available. It is noticed that an FIR was lodged on 19/10/2023 by the petition number 1 against the petition number 2, and accordingly, allow women case number 20 of 23 was based on a section 354, 427, 323 IPC. The allegation under section 354 relates to outrage the modesty of the woman. IPC.
354.
Relates to assault or criminal force to woman with intent to outrage her modesty. And punishable for imprisonment, either description for term which shall not be less than 1 year, but which may extend to 5 years. And shall also be liable to be punished fine.
No, not less than 2, extend up to 7 years. Arunachal amendment is there, Your Lordship. State amendment is there, Your Lordship.
Okay.
Yes, in column Arunachal Pradesh, in its application to state of Arunachal Pradesh. Imprisonment for not less than 2 years, but which may extend to 7 years. And
Where it is?
it's in table, Your Lordship, Schedule 1
Okay.
of the CRPC, Your Lordship.
Just keep it. Table 1.
Yes, Your Lordship. In table, Your Lordship, CRPC.
Who is Arunachal Pradesh? Andhra Pradesh.
Arunachal Pradesh, below Andhra Pradesh, Your Lordship.
in imprisonment of not less than 2 years, but which may extend to 7 years and with fine. Why this is not, this is it's not here.
Yes, your lordship, that may be the old one.
Because we are having the old one.
Your lordship, this is
It is-
after implementation
it is
of
not
BNSS.
That the offense under section 350 is serious in nature, that it relates to alters the modesty of a woman. The records next step reveals that immediately after the registration of the FIR on 19/10/2023, the no, comma, on the intervention of the family members and other family, comma, family and senior members as well as governors and public leaders of the area. The parties have settled the matter. The petition number 1 is a small business lady who is running a restaurant in the rented building of the relative of the respondent number, petition number 2. It appears that no, Mr. It doesn't disclose the agreement appears to be made voluntarily by the petition number 1 as the petitioners are related. They are family relatives also. Family relatives. It is noticed that the on 18/10/2023, the petition number 2 had entered the restaurant of the petition number 2. It also appears that the petitioners have some misunderstanding due to conduct and behavior of the petition number 2, which resulted in lodging on the FIR on 19/10/2023. Next one. Having considered having considered that the parties have settled the matters by our mutual settlement agreement on the intervention of senior members, senior family members, senior members and public leaders, including the governor. And considering that the offense, though serious, is not heinous, this court is of the view that the continuation of the investigation of the women PS case, all women PS case members, shall be futile and would amount to abuse of process of law. This court is of the considered view that interest of justice shall be served, would be served if the investigation of the FIR registered as Hello Women PS case number 2023 under section so is quashed accordingly. The Hello Women PS case number 20 of 22 under section so pending investigation by the Hello PS case number Hello pending investigation before the Hello police station is hereby quashed. The criminal petition is hence allowed and disposed.
Obliged.
In petition. So your party is over.
Have one more point that I could not touch. At the time of reply, I'll submit it.
No.
Reply has to be replied by me.
Then again you reply.
No, that is
2 minutes. 1 point.
only one.
2 more. 2 minutes. Yes.
But not the
That's a note. What is in the note? I'll have note. So yeah. You have note for names. Your note for name, file में रखो. File में रखो. ऐसे का. Okay, it's here. Keep it here. Yes.
That's why seen the.
Are you relying on judgment?
I'll submit that also.
Huh?
Yes, I'll be submitting the judgments also.
How many judgment?
Basically 2.
Not more than that.
What?
Not more than that.
Maybe one more.
Two will be enough.
I'll just the particular paragraph I'll.
Yes. What is the next point?
The
I
point,
mean, last point.
Lordship has seen, my lord, the eligibility criteria, which are at page 34.
Page
Page 34, starts from 1.7.
34.
34.
Hmm.
11, 1.7.2, 35.
Yes.
Here, the requirement is that
Hmm.
the 20% of the estimated cost put to the tender, one should have completed.
Which one?
Clause 1.7.2.
Yes.
The bidder should have satisfactorily completed the one work as mentioned below during the last 7 years, ending previous day of last date of submission of tenders. This point I have submitted. Provided that at least one similar work of 20% of estimated cost put to tender of rupees 317 crore, that is 63.40 crores, should have been completed. So, madam, the one work of 20% of the total, bid amount, one must have completed. And this has been clarified at page 41 that it should be within the period of 5 years. Page 41, clause 6.
No, this is not the clause, this is not the clause under which your bid was rejected.
But there I have already submitted. Now I am on the another point to say, to contend that this particular criteria, these are not the parameter to be rejected because Schedule D is there. Yesterday I have said.
So according to you, even if there is some aberration of this eligibility criteria, unless you follow the Schedule C and D, you cannot, there cannot be a ground for rejection.
Rejection.
See, on the simplicity, you cannot reject on the basis of this eligibility criteria. To find out whether you are eligible or not, the authority has to consider, I mean, and follow the Schedule C and D. So in this case, without resorting to the Schedule C and without following the Schedule C and D, Schedule D, you simply have rejected by having some interpretation of the
Because on the same ground,
criteria under 1.7.4. That is what you are saying.
no, now I am on the other one.
Because
1.
unless you follow Schedule D, right? Unless you follow Schedule D, according to you, this criteria cannot be made out for rejection.
Just because someone is in sort of the
Yes.
parameters that has been given,
Yes.
the base marks or the minimum criteria that has been given.
And for the reason that for 1 year, you have the turnover of more than 150.
That is with regard to me.
Yes.
1.7.4. Now
Yes.
I am on the 1.7.2. That is with regard to the respondent number 7. He also do not fulfill the criteria, but then he has been accepted.
But not under 1.7.4.
Madam, these
According to you, this he doesn't fulfill 1.7.2
are 1.7.4.
for respondent number 7.
Respondent number 7.
Okay.
If this clause can be relaxed, this 1.7.2 can be relaxed, then obviously, well, the 1.7.4 can also be relaxed.
Yes.
But in arbitrary manner, they have relaxed so far as the respondent number 7 and other persons, I'll take your lordship to them also.
Relaxation to R7. Yes.
So Form C, he has given the 5 years marks, and one work he has completed, he has shown. Yesterday, I have taken your lordship to that figure
Yes.
These 5 years is to be reckoned back from the last date of submission of the tender. Now, page 41, your lordship. Look at this email, this serial number 6.
Yes.
Value of similar nature work of executed during last 5 years. So one work has to be there within the 5 years.
Page,
And this
page,
page
page
41.
number.
clause
41.
6,
41.
41,
Yes.
clause C. 6. Value of similar nature of work executed during the last 5 years.
Yes, you have shown yesterday.
Yes, yesterday. Now, the format is given at page 52. 53.
Yes.
Form C.
That you have seen.
This is the last 5 years ending previous day of last day of
Yes, we have
submission
seen
of
that.
tender. Now, Form C of respondent number 7, lordship has seen, they have reckoned a date prior to that. So that clause they have relaxed, they have accepted him. If you can relax to him,
Why not to you?
it's an arbitrary rejected mine, my lord, or arbitrarily, my lord, accepted theirs, my lord. One aspect. Then Schedule D, your lordship has seen, my lord. The first at the time of bid opening, Schedule D, page 61.
Yes.
Page 61, at the time of opening, two things only they will see. The first is that proof of payment of bid of rupees 25,000. It is the receipt they have to give.
That you have done yesterday.
No, receipt is,
You have
receipt
shown
is,
all these things.
no,
You
no,
have said one point, you are repeating.
no, this,
same
no,
thing.
this is only one, man. This is only one to show that how arbitrariness they have done.
Yes, you have some, I mean,
Someone
all
has
these things
been-
yesterday.
Someone has been accepted and someone has
Of
been
course, the
rejected.
point which you have said arbitrarily relaxed and arbitrarily rejection, that is a point you have not said.
It's not, so
That's-
on that point,
Yes.
Article 14, what I am trying to make of, my lord. So these, here the two things they'll see, my lord. The first is that the receipt of payment of the bid fee. The receipt is prescribed under the, my lord, these forms. And the second one is the documents that have been uploaded as per Schedule C. Now, so far as, my lord, the respondent number 9 is concerned, my lord, though his name has been, he was subsequently, his name was struck off because he did not get the selection, but the statement are there and the reply is also there. He did,
If he's not there, why should rely on this?
no, I'm on the arbitrariness of acceptance and rejection.
It's okay. Why not concerned?
No,
Those
reply,
who are
reply,
been
reply,
struck off were not concerned.
no, reply by
Well,
the
not
government
take
is, reply by the government.
Government will consider, but
Yes, reply of the government. I'm not on the private respondent.
yes,
He has given the copy of the bank draft,
respond number 9.
respondent 19.
Why we should concern about? Forget about
No,
it.
why I'm saying the reply what he has the submitted by the government. This reply of the government is that they have subsequently verified and found that the bank draft has been deposited. So that clause is
So far as the respond number 9 is concerned, who has been already struck off,
stuck off.
then
Mother, he has not been selected.
will confine to you and the respond number 7.
7.
That's all.
No, these are the act of the tender evaluation committee. Therefore, I am just highlighting them because these clauses have, I am on to say that unless you go to the Schedule D, the rejection is not
Yeah, that's
permissible.
what
And therefore, you have been relaxing in respect of the other tenderers. So far as I am concerned, you have not done it.
Yes, yes.
But so on that matter, I'll submit the judgment.
Yes. On what point? Not few judgment, most relevant one or two. Why
I'll
unnecessary?
just give the names and paragraph.
But only most relevant two at
Yes.
first. Two judgment.
No, I'll not refer to the that your lordship will similar. I'll just give the citations. I'll just give the citations.
If you
That
just
will be
give,
shorten the time. That will shorten the time. The lordship is aware, but I'm just highlighting that.
no, I'll have to have my homework again. You give the just relevant on the point.
Yes.
Why so many? How many judgment?
No, I'm only two minutes.
Two judgment.
Only two judgments.
Just give that only.
Yes. This one is one of the AIR Online 2021 Supreme Court 131.
AIR.
Yes, well, that is that Unitech Limited case, matter. Unitech Limited case.
Hmm. 2000.
AIR Online 2021 Supreme Court 131.
2021. It's not reported in SCC.
No, it's a very leading case, but I have got the AIR, so I have got it in the Unitech.
Problem is all of us go for the most convenient one.
So this
Online and Supreme today.
I'll just supply the copy. Only one paragraph, paragraph 33, it has summarized all the earlier decisions of the with regard to the contract matters, what is to be done.
Name of the party?
Unitech Limited and others.
Unitech.
Limited and others versus Telangana State Industrial.
Paragraph?
Paragraph number 33.
Okay. Then next.
Should I read it or
It's okay. If it is reiteration of earlier decisions. And what does it say?
And summarized it in paragraph 33.
Okay, we'll see.
Summarize it at page 33.
Okay.
Then
next
will be G.J. Fernandez versus State of Karnataka.
Yes.
AR 1990. Supreme Court 958. I'm relying on paragraph 6 there.
Why you are AR? Why not SC? AR 1995.
AR 1990. Supreme Court 958.
1990. 958.
Para 6.
J.J. Fernandez.
There the issue is in respect of some tender, the tender has been the relaxed clause has been relaxed. In respect of someone, it was not there. Then what is the mandatory clauses and what is non-essential conditions? Even if the mandatory conditions have been relaxed by the authority in respect of some tender, that opportunity should be given to the others also. It should not prejudice the others.
Yes.
To that extent.
Why you are saying para 6? It's not para 6.
Para
16.
Para 16.
Yes, that's all.
And one last minute. AI Online 2022. Supreme Court 867. Jai Bholenath Construction versus Chief Executive Officer. It's para 6. So this judgment has been passed by Honorable Justice Hemant Gupta and V. Ramasubramanian, who has passed the, my lord, NG project case. And in NG project case, referring to the specific relief act provision 20 and 21, it has been said that the infrastructure development project.
So you are also relying NG project.
I'm not relying on that. I'm trying to distinguish by the particular Jai Bholanath Construction Limited. The NG project case was with regard to the interim or interim reliefs or interim order to be passed by the court, and it has referring to that specific relief act. Said development project should not be stayed. Okay, but so far as on the merit, if it is found that the decision is arbitrary, etc., in that case, yes, Lordship. These are the three judgments. Yeah.
Lordship, in this case, 13 bidders they participated, Lordship.
Yes.
Out of 13 Lordship, 5 bidders, Lordship. There have been Lordship, their bidders were rejected on the same ground, Lordship, including the petitioner, because they are not qualified in the turnover. This is not the petitioner who has been picked up, only he has been rejected on this ground, Lordship. 5 bidders out of 13, Lordship.
Same ground.
Same ground. Because they did not reach the Lordship turnover that mark, Lordship.
5, including the petitioner.
Including the petitioner.
Okay.
Another 4 persons are there, Lordship. Its details is given at page 27, Lordship, in the writ petition, Lordship.
Yes.
Page 27 of the writ petition. Lordship will find serial number 1.
Page 27.
27, Lordship.
Yes.
Writ petition. Serial number 1, Lordship. Navam Tulun. Turnover below minimum qualifying criteria, Lordship. Then serial number 6, Lordship. Down below, bottom. The same ground, Lordship. MS Sailaja Commercial Construction. And next page, Lordship.
Yes, yes.
On next page, Lordship, serial number 8, 10, and 11, Lordship. So here, Lordship, we have treat them equally, Lordship, all the petitioner. Then I'm taking Lordship to the Lordship RFB, Lordship. Relevant, Lordship, is 8 page 33, Lordship.
Yes.
Page 33, Lordship. Here, Lordship, though the petitioner bid has been rejected, since he has not reached the Lordship prescribed turnover, Lordship.
Yes.
If Lordship see the page 34, Lordship, just I'd like to take Lordship to paragraph, paragraph 1.7.1, Lordship. The enlistment status, Lordship. This comes under eligibility criteria, Lordship. Here, Lordship, just I'd like to read here, Lordship. The bidder should be either enlisted with any of the enlisted authority and shall be governed in accordance with provision as per the Arunachal Pradesh district-based entrepreneurs so and so Act, Lordship. Class 1AA, civil category enlisted contractor oblique firms under Arunachal Pradesh Public Works Department. B, Lordship, equivalent class oblique category registered under government autonomous organizations within brackets so and so involved in the development roads and highway project, Lordship. C, Lordship, for equivalent class oblique category, bidders will be bidders eligible to bid for so and so. In the present case, Lordship, though it is not the ground of the rejection, Lordship, as reflected in the minute, Lordship, but the petitioner is not the Lordship enlisted contractor. He is a company, Lordship. That particular reply we have made in our reply lawsuit. And that has been,
But that is not a ground of rejection.
that's correct lawsuit. But if that's admitted before this honorable court lawsuit, because it touches very root of the lawsuit, his competency.
You have not rejected on that ground.
Overlook lawsuit. But when matter is before this honorable court lawsuit,
You
it's
cannot
very,
overlook everything.
Yes,
You
I-
cannot overlook everything.
as I have submitted lawsuit, it touches.
And you
the-
have overlooked so many things about respondent number 4 or
I'm,
7 also.
I'm coming to that.
Yes.
I'm coming to the lawsuit.
So overlook will be
So,
very dangerous.
Yes, here it's very dangerous lawsuit.
Overlooking
safe lawsuit.
the points and the requirement.
I'm coming to that lawsuit. There's no overlook in that case lawsuit. I'm coming to that point
Yes.
lawsuit. In this case lawsuit, why I'm submitting it lawsuit? Because adjournment we have made lawsuit, reply has come lawsuit. In reply, there's no lawsuit proper reply near a sweeping statement denying the lawsuit that statement.
So he's not eligible.
He's not eligible. He's a company but not registered as a contractor under any authority laws. Why I'm submitting it lawsuit? Because it touches the very lawsuit competency of eligibility of the petitioner lawsuit to participate in very tender process lawsuit. And it's very important.
Yes.
That extent we have taken in our. Then coming
But
to
then
the,
that may not be relevant because his bid has not been rejected on not.
but when it's lawsuit, not denied lawsuit with supporting document lawsuit,
That
when
may
that's admitted before this honorable court lawsuit can take cognizance of that
It's
lawsuit.
okay, but that's not a
Then-
ground of rejection.
Then kindly come to next page lawsuit.
Yes.
I'm taking lawsuit to 1.7.4 lawsuit,
Hmm.
the financial turnover lawsuit.
Yes.
Requirement is lawsuit 158.50 crore lawsuit.
Yes.
Lawsuit, just I'd like to read this sentence lawsuit because interpretation lawsuit has already observed lawsuit.
Yes.
Interpretation lawsuit, the author is the person lawsuit who has to interpret it until unless that is very
But
lawsuit.
arbitrarily you cannot.
Yes, that's
It
true,
has to
lawsuit.
be interpreted
Yes,
properly.
yes, lawsuit. Then lawsuit, one lawsuit, just I'll read lawsuit. The bidder should have had average annual financial turnover gross lawsuit of not less than rupees 158.50 crore on any works contract during the last 5 years, balance sheet duly audited by the chartered accountant lawsuit. Lawsuit average cannot be taken out of one lawsuit. Average is always taken out of more than one lawsuit. 2, 3, 4.
The bidder should have had average annual financial turnover gross of not less than so and so on
Yes.
any works contract
So-
during the last available 5 years. Balance sheets daily.
So we have clarified this very interpretation in our affidavit lawsuit. What we state lawsuit? Last 5 years lawsuit, not necessarily of the similar works lawsuit. Any works, any contract work lawsuit. It may be the road, it may be the lawsuit building. If in last 5 years lawsuit, whatever contract works you have done executed lawsuit, the turnover will be taken out of, average will be taken out of all those works lawsuit.
Obviously, it is for it is for financial soundness only.
Correct lawsuit. So average
Not
is
necessarily for a particular work, cannot be. Because it's basically for financial.
yes, the overall lawsuit.
Soundness.
Overall lawsuit. So average is, as I said, average is never taken out of one lawsuit. Average is always taken out of more than one lawsuit. There's a simple interpretation so we can lawsuit adopt lawsuit. This very interpretation lawsuit, if lawsuit see the order dated 29/1/2024, passed by this honorable court, by which lawsuit the interim was vacated lawsuit,
Prima facie found.
prima facie found lawsuit, interpretations of the state government on instruction, the same interpretation has been lawsuit accepted by this honorable court lawsuit, and that went to the lawsuit honorable division bench. Division bench did not interfere. It went up to the Supreme Court lawsuit. And Supreme Court also lawsuit, so far this issue is concerned lawsuit, interpretation is, it has not been lawsuit, turned down lawsuit. And these very clarifications we have given our statement lawsuit. And there in their reply lawsuit, is not that lawsuit clear-cut denial lawsuit that interpretations. So that's the lawsuit. What
There is
I
no denial, if there is no other thing, it's good for you.
lawsuit. That's what I'm submitting lawsuit.
Yes.
And this is the ground on which lawsuit since the
So
petition.
according to you, The average has to be taken out from 5 years.
5 years.
5 years
The
on
works-
on a works contract.
Anyone, any works, lordship.
So according to, when you work out the average, maybe you've taken out on taking out the average of the petitioner of 5 years,
5 years.
it is below 158.
158.
Okay.
His
It's
is
simple.
his is 120.
There is the only ground.
That's only the ground laws we have taken
So
law.
that interpretation will be required
Required laws.
to determine the interpretation. Either
Correct.
yours is correct or his is correct.
Laws.
Yes.
And that we have given our interpretation laws.
Then next,
Then next is laws. Here two parts laws. Firstly, laws the petitioner's laws eligibility laws on which he is on second leg laws he has attacked the laws the eligibility of the private respondent number 7.
no, before that, what he said is to make a bidder, to consider the bidder as to whether he is eligible or not.
Laws.
So far as the financial soundness is concerned,
Laws.
1.7.4, apart from his interpretation. Simply, you just cannot take out and do it, reject it, because you will have to follow Schedule D. The marking system is there.
It's still
Once marking system is there,
laws.
if he gets 60%,
Laws.
60 marks,
Laws.
he is eligible.
No. I'm
That is what.
no.
You argue on
That,
that.
that's laws.
You
if-
prefer on that.
If lawsuit turn next page laws.
Then we'll go to the respond number 7.
That I'll come.
Yeah.
Then lawsuit, I'm taking lawsuit to the next page lawsuit.
Ah.
Next page lawsuit at page 36 lawsuit. It talks about the refer Schedule C and Schedule D lawsuit.
Yes.
Schedule C is the lawsuit mandatory documents to be uploaded lawsuit.
Yes.
It's a mandatory document lawsuit.
Yes.
And D is the only the evaluation procedure lawsuit.
Yes.
If and down below lawsuit, just I'd like to read lawsuit. Down below lawsuit, it's very pertinent again lawsuit. It's the applicability of the CPW manual and other rules lawsuit. Here it says lawsuit, the undersigned reserves the right to accept or reject any or all the technical bids without assigning any reason. Participation in this RFB also does not confer any assurance for selections of bid and award of contract. For any conflicting provisions mentioned in the eligibility criteria, same shall be dealt in accordance with the conditions mentioned in the so and so without overriding any statutory provisions of rules oblique JFR lawsuit. It's a CPW manual lawsuit, the applicability of CPW manual. Now I'm coming to this turnover lawsuit. Here, if lawsuit turn to next page lawsuit 61 lawsuit. 61. 49 is the Schedule C lawsuit, which is a mandatory document. Lawsuit, what it says lawsuit? 6.2 lawsuit. Here is the letter is lawsuit very clear language. In addition to fulfillment requirement laid in Schedule C lawsuit. In addition, technical eligibility shall be determined based on minimum score shown below lawsuit. This is in addition to that lawsuit.
Addition to Schedule C.
Addition to Schedule C.
Schedule C is a mandatory document.
Documents lawsuit.
And this is the procedure.
This is the procedure
of the evolution.
lawsuit.
Yes, process.
Now, these documents I have lawsuit. Here, if this language is lawsuit, suppose say it's a lawsuit, any kind of lawsuit, ambiguity is here lawsuit, then we can understand lawsuit. But language is very clear lawsuit. In addition to Schedule C lawsuit. So what else is here lawsuit to travel beyond this interpretation lawsuit?
No, what they're saying is you have not followed this process.
Followed lawsuit. I'll produce the record lawsuit.
There's no marking system and all.
It's there lawsuit.
It's there.
It's there lawsuit.
And what about he?
And this is
Has he got 60 marks?
yes.
Then, according to him, if a person bidder
If C is not fulfilled lawsuit, then he will be rejected.
To become eligible, the bidder must secure with minimum score of 60 out of 1 shown in the table with
But
When
this
it
is,
indicated here, besides fulfillment of mandatory condition prescribed as Schedule C.
this is any addition to Schedule C, Lordship.
That's
If Schedule C, Lordship, if you do not, Lordship, kindly on the top, Lordship, minimum opening, bid opening committee, the top, Lordship, during the opening of technical bid shall verify the following documents uploaded during bid submission as a prerequisite for carrying out further evaluations of technical responsiveness of bidders. Lordship. Schedule C is, Lordship, is a substantive requirement, Lordship. If one do not fulfill, Lordship, Schedule C, Lordship, even if he qualify in Schedule D also, Lordship, he is not qualified, Lordship.
So then proof of payment of bid fee of 25,000. It's he no issue.
No issue, Lordship.
Then valid contractual registration certificate.
Lordship, so by that was, as I submitted, Lordship, that it was not the ground for rejection, Lordship, petitioners.
But you said you have relied on the is not a class 1 AA.
Lordship, it's not class 1 AA, Lordship.
Okay.
Petitioner is not class 1 AA, Lordship.
No, it said or and of equivalent category under other state national investment authority.
Lordship, what I'm submitting is not registered under any competent authority to execute this work, Lordship. That's the contractor. As a contractor, he is not enlisted under any authority.
Yes, then
so my submission here is the Lordship. Schedule D is, Lordship, in addition to Schedule C, Lordship. One has to qualify the Schedule C, Lordship. The petitioner has not qualified in the Schedule C. Therefore, Lordship, the petitioner's bid was rejected along with the others, Lordship. Others also same issue. Another 4, Lordship. They qualify in the market.
Because Schedule C is a requirement of submission of the what we call chartered accountant the audit.
Schedule C.
Schedule C. What is
Schedule C. Turnover. Schedule C is inclusive of all documents, Lordship, even the registration, Lordship. 49 page 49, Lordship. Schedule C is the consists of so many substantive
No, my
documents.
concern about only clause 9, 5.1, Roman 9. Certificate of annual financial turnover with profit loss details for the last 5 years from chartered accountant.
Lordship.
Form A. That he has submitted.
Petition has submitted, Lordship. Petition has submitted, but that is below, Lordship, 158.5.
No, see, your schedules D doesn't say it's in addition to the eligibility criteria which you have provided in RFP. It only says in addition to the Schedule C. And Schedule C is a documents, mandatory documents to be submitted, which he has done. With the question of below or above, once you get the 60%, 60 marks,
this
after a process in the Schedule D.
Lordship, here, Lordship will find page 35, Lordship, the RFP, Lordship, financial turnover, Lordship.
No, that's I've said.
The average, Lordship.
Yes.
That is prescribed.
But then
Here it says, Lordship.
see, your Schedule C mandatory documents,
Lordship.
Roman 9,
Lordship.
certificate of annual financial turnover. It's a mandatory document.
Mandatory document, Lordship.
Which he has uploaded.
Uploaded, Lordship.
Below or average, forget it.
Yes, Lordship.
Then
But
next is page 61, right? Schedule D. This
Lordship.
is the process.
Lordship.
By this process, you have to award some marks. If a bidder obtain a minimum of 60 marks out of 120, he is eligible. And this is in addition, it is thereon besides fulfillment of mandatory condition prescribed in Schedule C. Mandatory is for submission of the documents,
Lordship.
Schedule C. And once you get the 60 marks, is eligible.
No, Lordship. Here, Lordship, documents requirement that under Schedule C, Lordship. That has to satisfy the Lordship 1.7.4.
What does it say?
This 1.7.4 lawship.
What does it say that the documents under Schedule C has to be in terms of the eligibility criteria?
No, Schedule C is the list of the documents only, lawship.
Yes.
And list of the documents, you satisfy lawship the average annual turnover.
Then come to it. It's a mandatory documents to be submitted.
But in
Schedule C.
consonance with the requirement under 1.7.4.
Where it is? Where does it say?
1.7.
Where it is said?
No, 1.7.4.
Where it is said?
No, here 1.7.4 it says lawship. The
Check.
bidder should have had average annual turnover of not less than 158.50 crore lawship.
As per the Schedule C? Is there anything like that?
No. Schedule C lawship is a list of documents which you are supposed to submit lawship.
Yes.
In support of the condition lawship.
Then you should mention in as per the list of documents submitted in Schedule C. See, Schedule C provides the mandatory documents to be uploaded, or
Correct.
submitted,
Correct, lawship.
right?
Lawship.
Then next process is Schedule D. Schedule D, there's a procedure and a process. You have to award marks to the bidders. The bidder who gets 60%, 60 marks out of 120, he become eligible. Besides Schedule C documents.
Lawship, yes.
Nowhere it says either the Schedule C or Schedule D that is it besides or in addition to the eligibility criteria provided in the RFP or financial soundness.
Lawship, that
Or your 1.7.4 doesn't provide that this average turnover
lawship.
has to be in terms of the Schedule C or in addition or besides the Schedule D. It doesn't say so.
Lawship.
That's why yesterday also I pointed out,
Lawship.
it doesn't look, contradictory and or else if you go to Schedule 6, Schedule D, your 1.7.4, it appears to be redundant. It's a contradictory.
Lawship, yes, yes. Here, lawship, RFB lawship, we propose some requirement lawship.
Yes.
One among them is lawship 1.7.4 lawship, where we demanded lawship, you submit average annual turnover of 5 years above lawship 158.50 crore lawship.
Yes.
There's a precondition lawship. In order to satisfy that lawship,
That precondition has to be in consonance with the terms of your this schedule.
No. Schedule C comes after lawship, this condition only lawship. We have demanded by this RFP lawship. Then in support of that very condition lawship, they have uploaded the Schedule C.
Yes.
Schedule C comes after this condition only lawship. First, this fulfillment of this condition lawship, you have to fulfill it by submitting the Schedule C documents lawship. Then followed by D lawship. First condition lawship. Because if condition is there, if not there lawship, questions of submission of Schedule C does not arise lawship. Schedule C has to be submitted in compliance of the terms and conditions prescribed under the. Oh, sorry, lawship.
Yes.
My submission was there, lawship. So far, lawship, terms and conditions concerned lawship. Basically, that is prescribed lawship in the NIT lawship, RFP lawship. Tender process is started from that NIT lawsuit. And in order to get satisfied those condition lawsuit, the list of documents are submitted, which is Schedule C lawsuit.
Yes.
Schedule C comes after lawsuit, those terms and condition lawsuit. To satisfy those terms and conditions, Schedule C is prepared lawsuit. Basing on those document lawsuit, the evaluation has to be done lawsuit. Evaluation has to be done. So in evaluation lawsuit will find the requirement is lawsuit, the substantive requirement that is prescribed under the terms and conditions of the NIT RFB lawsuit. And this marking lawsuit, grading is lawsuit, in addition to those requirement lawsuit. Yes, I submitted lawsuit. Here lawsuit, just I have obtained these documents from department lawsuit. Here lawsuit, this marking has been done, Lordship. Thereafter, Lordship, how much point they have secured, Lordship. Then they are responsive, substantive responsive, because they have not qualified turnover and some does not fulfill the particular document required under the terms and condition. Those have been found to be non-responsive, Lordship.
Okay.
This is the final, Lordship. And so far this grading is concerned, Lordship, there is not pleaded case in the writ petition, Lordship. In this writ petition, Lordship, it is not the pleaded case.
Grading in the sense?
No, this Schedule D issue, Lordship, that is not pleaded in the writ petition, Lordship.
Yes.
That's not pleaded in the writ petition. So this is, Lordship, my simple.
This is the, but then this is the requirement of your terms of the tender requirement.
That's correct, Lordship. That's
It's your
correct.
documents only. These are the process. Schedule D and Schedule D, C and Schedule D are the, has to be mandatorily complied with.
Lordship, Group D, Lordship. In addition to, Lordship, Schedule C, Lordship, you have to qualify, Lordship, as per terms and condition, Lordship. You have to qualify, Lordship. In addition to, even if you are qualified.
His case has been considered, process has been done as per Schedule 3,
Done, Lordship.
60,
Done, Lordship. Yes,
not 60 marks.
60, Lordship. Others also case, Lordship. Others also, Lordship.
Whatever, respond number 7,
7 also fulfill, Lordship.
60,
More, Lordship.
more than 60.
Lordship.
He is
Is also more than 60.
more than 60.
Most of the, Lordship, more than 60, Lordship.
Schedule D,
Schedule
all
D.
of them.
All of them. Most of yeah, Lordship.
all of them.
No, not all of them. Most of them, Lordship, they qualified. And their cases also have been rejected, Lordship, because they did not fulfill the turnover requirement, Lordship.
So according to you, as per Schedule 1.7.4,
Lordship.
his average turnover of 5 years
Lordship.
is below 158.50
158.
crore. Therefore, he has been rejected. Not
Rejected.
only he, not only the present
Other also.
petitioner, another four
Lordship.
bidders.
Lordship.
And as per Schedule C and D, there is no problem. It has been considered. As per Schedule D, he has submitted
Lordship.
the documents, but then doesn't fulfill
The substantive
as per
requirement.
1.7.1.
Correct.
1.7.4.
Correct. Correct, Lord.
And so far Schedule D is concerned, it has been complied, it
Yes.
has been followed,
Followed them.
and he has, the petitioner scored 60,
60.
more than 60.
More
or
than
more.
60.
Has it been annexed?
No, no. Lordship.
How do you have the records?
Lordship, this I obtained. Yes, I can furnish it to this honorable board. Lordship.
Yes, that I've understood now. Therefore, the whatever may be interpretation,
Lord.
so they say that out of 5 years, he has got more than 158 in one year.
Yes.
It's more than enough. It is sufficient.
Yes.
So consider 1.7.
This their case.
Ah. No, your interpretation is that we have interpreted that way as per the requirements.
Yes.
The average of 5 years.
5 years.
To be there. If average is taken, it's below 150.
Below 1.
So the interpretation of the author of the tender
Correct, Lordship.
should be accepted,
Lordship.
not otherwise.
Lordship.
Is not it?
This is my.
It may be a wrong interpretation.
Maybe wrong,
Yes.
maybe right, Lordship. This, but that is
Now,
that is in consonance with the
next, whatever response number 7.
7, Lordship. I'm coming to that, Lordship. If Lordship say the kindly take up
Why
the-
you have accepted all those documents? That is page. How you have accepted all these documents? Page 53, form C, column 10 is missing. So far as the respondent.
I'm coming to that, Lordship. First, Lordship, so for turnover is concerned, Lordship.
Ah,
For in respect of private respondent, Lordship.
yes.
Kindly come take up Lordship SOP, Lordship, 2022.
Yes,
SOP lordship is available with manual, 2022 manual.
yes. It's there.
Yes, I have.
Yes.
If lordship turn to page 34 lordship. Down below lordship, pagination is here. Take care. Huh? 19, 20.
Yes.
Lordship will find laws. This is the lordship governing SOP lordship. If lordship come to next page lordship, 4.9. 4.9 lordship.
Next page.
Next is lordship 4.12 lordship. 1.2 CPWD enlisted contractors lordship.
Where is it? Page?
Page this is lordship 35 lordship. Otherwise, kindly take up my lordship affidavit. File in IA lordship.
Tenders procedural work of bill. Where is page for the SOP?
ये manual नहीं है.
Huh?
समझ नहीं है.
This is by you only. You have given this.
No.
I think we have supplied yesterday.
This is part of SOP number 4.9 lordship. Close to lordship. Top lordship. Close to. Close one is in another page lordship. The first page. May I read lordship? CPWD enlisted contractors above class 1 building and road so and so category are allowed to participate up to their tendering limits without submitting eligibility documents except eligibility document required under para 2D below. This is for lordship those contractors who are registered under the CPWD lordship. There's a PWD here lordship. The private respondent number 7 is the PWD registered contractor lordship. He has to submit the documents required under 1D only lordship. A 2D. 2D down below lordship for EPC tender. Here lordship A2A is the three similar works is not required for the APPWD registered contractor. 2B also is not required. 2C also is not required. 2D is required also. For EPC tender under mode 1 and 2, only applicable for CPWD enlisted contractors of appropriate class also. One completed works costing not less than 20% of the estimated cost put to tender or 200 crore, whichever is less educated with the structural system technology as proposed by the bidder in letter of transmittal during the last 7 years, ending last day of the month, previous to one of which tenders are invited. This work can be part of eligible work at close to above or a separate work lordship. Two things are required to be lordship noted here. One is lordship, it talks about the any works lordship. Any one completed works which is more than 20% of the total tender lordship. And it can be lordship the part of the eligible work as mentioned in the lordship clause 2ABC or as a separate work lordship. In the present case lordship, the private respondent is a lordship sole contractor who is registered under Andhra Pradesh Public Works Department lordship. He's a local contractor here lordship. And
applicable for CPWD enlisted contractors of appropriate class.
Lordship. Here the PWD lawsuit. We have stated in our affidavit also lawsuit. Here
See,
is
your listing is, two is CPW enlisted contractors above +1 building and roads.
are allowed to participate up to date
without submitting eligible accept eligibility documents.
under para 2D below.
Non-CPWD contracts are required to submit eligible. This is for CPWD, not for APWD.
CPW is Central Public Works Department lawsuit.
Yes.
No, this we are following this lawsuit. Here lawsuit, the CPWD has to be substituted by the APWD lawsuit. Public Works Department lawsuit.
Yes.
Here lawsuit, 2 points which needs to be lawsuit noted here is the law. One is lawsuit, one completed works lawsuit. That may be any works lawsuit, not necessarily of a similar works lawsuit. One completed works, but the value must be not less than 20% of the total tender lawsuit, tender amount lawsuit.
So it's for all.
Lawsuit?
It's all for all bidders.
No, this is for APWD registered contractor only lawsuit. That's what lawsuit, it says lawsuit
So it will not have an application of the petitioner.
to the petitioner and other bidders.
How can you be? This is for CPWD and non-CPWD. If you want to distinguish, you should put it in the condition of the contract. I mean, in the RFP. Have you put it?
Therefore, lawsuit, I read lawsuit, the RFP.
Rules and RFP, not rules and RFP. It's the rules and
GFR.
GFR.
The
It
rules-
doesn't say the CPWD manual or the SOP.
But CPW manual is equally, it's a rules
It
lawsuit.
would amount to discrimination. Or else, if it doesn't discriminate, you should have, why should you have for same tender, why others should have a different conditions?
Because lawsuit, this tender is
And it's
invited
a hidden,
lawsuit.
it's hidden one. If you rely on this,
It's
it's not place, I mean, this is not given in your NIT or the SBD. Is it given? Has it
lawsuit,
been given?
lawsuit. Therefore, lawsuit rules. So for applicability of this CPW
So
manual,
back, rules is something else. It's not a rule.
lawsuit, this CPW manual is
It's not
applicable.
a rule.
No, it may not be a rule
You
lawsuit.
read the preface or something like that.
Lawsuit. What? Like, keeping aside
It's not
that
a
law,
rule.
keeping aside that lawsuit, what I'm submitting is lawsuit. The
So
application
what you are trying to say, as per this SOP,
lawsuit.
the bidders who have registered or the APWD contractor
Lawsuit.
will be applicable to this SOP. And it will not applicable to others who is not a contractor.
No, what I'm submitting is lawsuit. So far, this similar nature of works is concerned lawsuit. Those contractors who are not registered under Origin
PWD.
Public Works Department lawsuit, they have to submit some extra lawsuit qualification.
Why?
Lawsuit, because lawsuit, the logic is very simple here. Because these contractors are registered in Arunachal Pradesh Public Works Department lawsuit. And at the time of registration lawsuit, all these eligibility lawsuit, the condition.
Okay, have you given all these things in your RFP? There's the SOP, the CPWD manual and the SOP will be applicable.
Lawsuit, that is not their lawsuit.
Then,
But we are
then
not,
why you have a different conditions?
but we are not this, oh, no.
different terms and conditions for different, bidders.
But we are not disputing the lawsuit, the applicability of CPW manual lawsuit in our state lawsuit.
But then for a certain particular tender, you cannot have a different condition. That the contractor, PWD contractor has to, Arunachal PWD contractor has to have this condition and others should not. If you want to apply that, you have to prescribe in the tender. Otherwise, it's a, how do we know?
Lordship, CPW manual, like contractors, Lordship, they are not the laymen, Lordship. They know, they, every day they are dealing with the.
You know, what's the problem in putting it up? Because it's a CPW manual, it's not an act that it will have to be automatically applied. There's so many conditions which you don't follow, though you follow the CPW manual.
No. Lordship, this SOP has been even realized by my senior friend for the petitioner also, Lordship.
Yes.
Applicability is not disputing.
No, applicability, I'm not saying. The conditions
No.
which you want to, if there's a different conditions
No, sir.
for different bidders, should be provided.
Lordship, that may be their Lordship, but
Because you are distinguishing the non-FED contractor and the FED contractor.
no, sir. This is Lordship CPW manual, which
As if you are giving preference to the
Look-
PWD contractor.
Lordship, this is a central manual, Lordship, which we have adopted, Lordship. So this, it was formulated by the central government.
Anyway,
So we
please
have
proceed,
adopted,
huh?
Lordship. So this condition is there, Lord. This guidelines is there, Lordship.
There's a different condition for different bidders. Huh?
Bidders, Lordship. And Lordship, this is not issue before us, Lordship. It is not the issue before us, Lordship, and it has not been challenged also, Lordship.
Then why you are raising this? Why you are relying this? Why you are relying this?
Relying is because, Lordship, the petition, a private respondent, being a Arunachal Pradesh Public Works Department registered contractor, Lordship, he has submitted, Lordship, one completed works, whose value is more than 20% of the tender amount, present tender amount, Lordship. He satisfied that particular condition. That's my submission. In order to support that, Lordship, if Lordship say
So he doesn't have to have that turnover of average turnover of 1.58 crores
Lordship,
for last 5 years.
Lordship,
He doesn't require.
doesn't
He doesn't have to.
require.
That is exactly that will be the discrimination. You are rejecting a bidder
Lordship.
who requests to submit the average turnover of 158, and for some other bidder you are saying that it is not required,
Lordship,
and there is no prescription, there is no provided in the RFP or the tender.
for now, Lordship, we are in the Lordship similar nature of works, Lordship.
Same thing, similar nature. Average, that's why I'm asking. The bidders,
Yes.
who is a contractor,
Lordship.
Arunachal Pradesh PWD contractors, does not require to furnish a turnover for 5 years of 158 crore.
Lordship.
Is it a requirement or is not a requirement?
Lordship, it's not requirement as per CPW manual, Lordship.
Ah.
This is not creations of our state, Lordship. This
Ah.
is CPW manual created by central government, which we have adopted, Lordship.
So other non-contract PWD contractors,
Lordship.
they have to submit 158,
158, Lordship.
average turnover of 158 crore.
Correct, Lordship.
PWD contractors, doesn't requirement, there's no requirement. This is what you are saying.
Yes, that is one of my submissions.
Therefore, there's a
Otherwise
there's
also.
a different condition for different bidders. And you have rejected the
Lordship,
other contractors, PWD contractors on a different conditions and accepted your PWD contractor in a giving a preference of different conditions.
Lordship, otherwise also, Lordship.
Is
Otherwise,
it your case?
no. I have to
Is it your submission?
Yes, this is my submission.
There's a different conditions
Condition,
for non-PWD contractor and the.
that is laid down in CPW manual, Lordship.
This ground, you are interfering.
Lordship, this is one of my submission, Lordship, because it's provided under the CPW manual, Lordship.
How can you do that?
Lordship, this is not
In the same tender,
Lordship.
it's a common sense. Why you should have a different conditions?
Lordship, yes, I have submitted, Lordship.
Now that's why I'm asking, is the non-PWD contractor
Lordship.
required to submit as per 1.7.4. Others PWD contractors, do they need to submit that?
Lordship, as per this CPW manual, is not required, Lordship. Even in the,
Therefore, you have taken that.
even then in the
You
present,
have provided in the RFP,
Lordship,
tender, 1.7.4, 158,
Lordship,
turnover, whatever. One has to submit that, all the bidders.
Lordship,
But you are saying for non-PWD contractors, it is not required.
Lordship,
What is this?
Lordship.
And on that ground,
Lordship, we
you
the
have rejected the,
Lordship tender inviting authority. We are not saying out of our own will, Lordship. This was Lordship.
you have to
Manual
prescribe.
say-
You are the tendering authority, you have to prescribe.
But
They have
applicability,
to have a equal level, they say.
but applicability of CPW manual is common for everyone, Lordship. It's not applicable for one and not for other, Lordship.
Level playing field.
It's applicable for everyone, Lordship. This CPW manual, Lordship.
So your PWD contractor,
Lordship.
Arunachal PWD contractor don't have to file, they submit the Schedule C documents.
No, they have to.
Then
No, they have to submit. There are so many documents in the Schedule C, Lordship.
nine, that
9. Lordship.
1.59.
Here, Lordship, what I'm submitting is here, Lordship. As per CPW manual, Lordship, it's not required, Lordship. But even then, in the present case, Lordship, private respondent number 7 submitted his, Lordship, turnover, which, Lordship, reached to, Lordship, 158, Lordship.
158.
That's what I'm submitting, Lordship.
If it is
So
not-
this submission, Lordship, my past submission, is not out of, Lordship, tendering authority, Lordship. This is what, Lordship, this CPW manual says, Lordship. Just we are, Lordship, placing it before this honor court, Lordship. And this is not that this terms and condition has been
No,
prescribed by.
that's why I'm asking,
Lordship.
why if it's not required, why you are submitting that, why you are placing that? If everyone has to submit that documents in the Schedule C
Lordship.
about the turnover,
Lordship.
everyone's, the documents will be considered, whether it is below or above the 158.
Lordship.
It's applicable to all. All the bidders have to submit that,
Lordship.
whatever respondent number 7.
Respondent number 7 also submitted, Lordship. Submitted
What about its?
his, Lordship, if the document is, Lordship, excluded, Lordship, which is said to be, Lordship, in Lordship, if Lordship's Form A, Form A and the Lordship, the banker certificate, Lordship, some Lordship mismatches are there, Lordship, as placed by my senior friend yesterday, Lordship. But if we come down to the Lordship, the lowest Lordship, the turnover, Lordship.
Let us clarify. Page 49. Schedule C.
Page 49. Lordship.
These are the mandatory documents to be uploaded.
Correct, Lordship.
Roman 9.
Lordship.
Certificate of annual financial turnover with profit loss details for the last 5 years from chartered accountant in Form A.
Lordship.
Then, what are the respondent number 7?
Respondent number 7 has submitted this
Submitted.
document, Lordship.
Then, is it in accordance with 1.7?
Correct, Lordship.
1.7.4.
Correct, Lordship. But
What is his turnover, average turnover?
average turnover is at page, Lordship, 123, Lordship.
123.
Lordship.
Yes.
This is more than, Lordship,
1, 2, 3, 4, 5. Yes.
more than 158, Lordship.
Hmm.
More than 158. This.
Then next page.
Next page, Lordship, turnover certificate, Lordship.
2018 and 2019. There's a difference in the figure. 172. This is 176.
Lordship. So,
Turnover certificate.
Lordship, this, what I'm just, Lordship, one point here, Lordship. Just,
Yes. What is?
here, Lordship,
What have you done to
what
this
we
discrepancies?
what we have sought is a Form A, Lordship. Form A is at page 123, Lordship. It was before us, Lordship. And as per Form A lordship, we found it correct lordship, it's more than 158 lordship. Then accordingly, all these anomalies lordship, whatever the petitioner is pointing out lordship, it was not before us till today lordship.
Which
Till
one?
today, no complaint has been lodged
124 was not there.
lordship.
This is submitted by. Is it not a part of the
But
record?
this is part of record only.
124.
These documents are
Part-
submitted by him.
Yes, then.
And Madam, this is in consonance with the clause.
Lordship.
because The A form has to be supported by the CA certificates, has to be supported by
Yes.
audited profit loss and accounts.
So whatever, there's a clear discrepancy.
Lordship,
Difference in page 123 and page 124,
lordship, this
176 and 172.
72 lordship. So basically, at the time of evaluation lordship, this turnover certificate, page 124 lordship. Lordship, we
You ignore this.
it's not like that lordship. So
Justify what-
intentional and one non-intentional lordship. At the time of evaluation lordship, every minute lordship, sometimes that is not possible. If lordship see the schedule C lordship,
No,
what
see, that will be, I mean, too strange. You are rejecting somebody on certain grounds.
lordship?
And you say that it's not possible to see every minute.
No.
What is the process?
What
of
I'm submitting?
evaluation?
Well, now what I'm submitting is
You
lordship.
have to go, you have to see minutely. You
Lordship.
have a comparative assessment. of the-
Lordship. Here, lordship, what I'm submitting is
Next comes the arbitrariness.
lordship. What I'm submitting is lordship. As per clause 9
That means
lordship.
you,
Close-
if the bidder whom you want to favor, you will just ignore. Chalo. Just pass on.
Lordship,
And
what?
if the bidder you don't want,
Lordship, what I'm submitting.
meticulously and microscopically you will examine, evaluate.
Lordship, what I'm submitting is
What that
lordship.
is.
What I'm submitting is lordship.
Yes,
As per clause 9 lordship, we have demanded the Form A lordship.
yes.
And Form A is 123 lordship.
That is.
And we
that
have
is-
gone through the 123 only lordship.
Yes. So you have ignored the 124.
124 lordship, we have not ignored, that's not the ignoring of 124 lordship.
This
But
is-
we
this-
have.
This was uploaded. It's a certificate of the turnover certificate by the what do you call? Chartered accountant.
Lordship. And for now, lordship,
It's a part of Form A. In fact, you require to give this certificate only. Form A is in fact is 124,
lordship.
not 123. Though it is written Form A.
No,
If we read the Schedule C, it has to be in Form A, but then the certificate of the turnover by the chartered accountant.
the Form A is by the chartered accountant only lordship.
Yes.
Form A lordship.
But why you need to have this, in fact, you need to consider this only, 124. It's a part of your thing only, Form A, 124.
Lordship. Oh,
It's
definitely.
it's a part of this 123. Or we can say it's a continuation. But when you read the clause, Schedule C, it is a certificate by the turnover certificate of the chartered accountant. Right?
Lordship.
Have I understood? You have ignored page 24. Page 124 ignored by the respondent.
Lordship, even lordship, if this particular lordship, anomalous lordship, the mismatch between the lordship turnover certificate and lordship, the Form A lordship. If that amount also, even if that's corrected also lordship,
Yes.
even that amount is corrected lordship. The
No,
turn-
ultimately what they are saying is these documents are manufactured and it is not a genuine documents which the authorities has failed to consider. These are all fake documents. It's not, it cannot be, it's not an authentic document.
Lordship.
You have just supplied, which shows that there's a clear differences and discrepancies, but then you have ignored this. That is their claim by relying on all this.
Lordship, this document, Lordship, even if Form A or this turnover certificate, Lordship, if we go by either also, Lordship, his turnover reached to 158, Lordship.
It's not a either. If they are alleging that these documents are not genuine, you have to justify. Because it's clearly reflects the differences and discrepancies.
Lordship.
Same year, you are relying on 1726275. Then same year, the same the turnover, you have a different figure. So it indicates that it's not a genuine document which you have ignored. And on that basis, you have awarded a work to the respondent number 7. That is what they are saying. That you have to justify.
Lordship,
Just
substantially.
ignoring just because you have committing wrong. Suppose these are not the, suppose these are, let us assume that this first one is the genuine one. Second one, if it's not genuine and if it's not required, you have to specify that. Because you say the requirements we want is only Form A as page 126, which we have taken note of and evaluated. And if the second 124 is not a requirement, required documents, then you have to specify that these are not documents. Maybe there may be differences. One not, it's not documents to be considered at all. You'll have to make that stand, if at all, if you have. But saying that even if there's a difference, if we calculate, I mean, genuineness is being questioned by the petitioner.
But substantially, Lordship.
And this is one document.
No, what?
Other what about other documents?
I'm coming to that.
Yes, you come to that.
Lordship, substantially.
You have ignored.
Substance.
We have
No.
accepted-
1.7.4, Lordship.
We taken note of it.
Substantially, it has Lordship, satisfied that, Lordship.
This court has taken note of it. That there's a clearly there's a difference, right? And discrepancies, and you have taken the Form A at page 123, not the certificate at 124.
Lordship.
That's all. You have not taken into consideration of 124, page 124.
Lordship.
Which in fact should have been taken into consideration because it's a certificate by the chartered accountant.
Lordship. And 123 is a certificate, Lordship. This is also issued by the chartered accountant.
How could you have this kind of
No.
two
123 is issued by the chartered accountant only, Lordship.
Then what about 124?
24 also is by the chartered accountant, Lordship.
Page 123.
In fact, 123 is certified. This has been prepared by the respondent number 7, and this has been certified by the chartered accountant.
Lordship.
And the turnover certificate is by the chartered accountant is at page 124. Right. This is certified by the chartered accountant 123, prepared by the respondent number 7, and the certificate which is supposed to be uploaded or submitted is at 124.
And this supporting document needed because of the very fact that supported by figures in balance sheet and profit and loss account to be financed by the source.
Here, Lordship, my one submission may be noted, Lordship. Here, Lordship.
And there is no profit and loss account.
Down below,
Profit and
Lordship.
loss is given.
Profit is given, Lordship.
Okay.
Down
Profit.
below. Here, Lordship.
Page 125.
Yes.
Here, my one submission here, Lordship. Substantially, Lordship, either if it's satisfied the 1.7.4, Lordship, that may be noted, Lordship. Lordship, it does not interfere with the Lordship, the competency of the private respondent number 7 to
No,
execute the work, Lordship.
if the authenticity or genuineness of the documents on the basis which the award is awarded, I mean, the work is awarded,
Lordship.
it has to be looked into. If you have ignored the genuineness of the documents,
Lordship.
these are the documents on which you have awarded the work to the respondent number 7.
Lordship, therefore, Lordship, the issue is, Lordship, substantially how it causing the Lordship, Lordship,
I
from
think if we go deeper, yes,
and this issue, Lordship, though Lordship, it was never raised by the Lordship petitioner before the authority till today, Lordship.
he is raising before us,
That is their Lordship.
challenging your action because you have ignored all the documents of the
Then other one, Lordship, the other one, Lordship,
yes,
other one is
missing
Lordship,
of column 10.
column 10. Then missing of column 10, Lordship,
Where is that page? Where is that page?
131.
131.
130.
130?
Of the petition.
130.
130.
Yes. Annexure 10.
Lordship, here, Lordship, similar nature of works. It talks about the similar nature of works, Lordship.
Yes.
Here, the substantially, Lordship, what
Yes.
is required is already given here, Lordship.
Oh.
How it affects the Lordship, the competency of the private respondent as a contractor, Lordship.
Now,
to execute-
what column 10 contains?
Page 53.
53.
Whether the work was done on back-to-back basis? Yes.
Yes. Yes or no?
Yes.
It's missing.
Yes and no missing. Lordship,
And supporting.
these,
document
Lordship,
is
yes
on
or no,
subcontract-
Lordship.
And the supporting document that they have given is on subcontract basis.
Okay.
Is 131.
What they are saying,
Lordship.
since they have not worked, they have not done any work back-to-back basis.
Lordship.
Therefore, conveniently they have deleted the requirement
Lordship.
because the supporting documents which he has submitted is as a subcontractor.
Subcontractor in respect of serial number 1.
Yes.
Lordship, that is, Lordship, back to back, Lordship. This is not a substantive, Lordship, condition. The prescribed under the NIT laws, RFP laws. That if this is not done, then it will be rejected.
This also you have ignored.
No, it's not the Lordship that ignore or
See, these are the
intentionally,
required documents.
intentionally nothing
These
has
are
been.
the required documents which you need to consider for efficiency or otherwise.
Now, Lordship, when
The documents,
Lordship.
the alleged unauthenticated or the fake documents, you are saying it is not substantial and you have ignored it. What
No,
is-
we have ignored it. That's not my submission, but
Yes.
that is, Lordship, now when that was not
No,
considered.
it doesn't mean ignore. I mean, as good as ignoring the same, because you know that there's a discrepancy. See, for example, this page 153,
Lordship.
you have the format, you have supplied the format,
Correct, Lordship.
and the bidders, they are submitting the format by deleting their own. the requirements which
No.
you have provided.
Lordship.
You have not done anything on it. You are not saying anything yet. You are just saying this is not substantive. Does it not amount to ignoring the documents, which is not as per the requirements?
Lordship.
Forget about the
Now, Lordship.
substantial, not substantial.
Now, Lordship, we are examining the issue, Lordship.
Yes.
Whatever had happened, Lordship. Now, at this stage, Lordship, how substantially it affects the Lordship, the competency, eligibility of the petition.
No,
This honorable court has to see that,
we are
Lordship.
determining whether the award is properly, I mean, the work was properly given in terms of the NIT.
NIT Lordship. Yes, that's correct, Lordship. But
For that, the documents which they are alleging is the maximum, the documents which they have shown
Lordship.
are fake, it's not genuine. Still then you have awarded the work to the, on the basis of all these documents, you have awarded the contract to the respondent number 7. That is the allegation. You have to
Allegation.
justify.
The allegation is there, Lordship.
And as of now,
But as
it
of
appears that the documents which they have placed
Lordship.
to be,
Yes.
at least to be not genuine or fake, you are just saying it's not substantial and it doesn't make any bearing on the
Because
efficiency.
today, Lordship,
Efficiency we are not on now.
we can't review the thing now. What did happen. But as on today, Lordship, we have to see, Lordship, this omission, Lordship, how it is affecting the Lordship construction of the road, Lordship, how it will affect the public interest, Lordship.
We are considering whether the contract has been awarded properly or not.
Lordship, the omissions of clause 10, Lordship. So on that point, my submission is, Lordship, that omission may be there, Lordship, but it as of now, Lordship, it doesn't, Lordship, substantially, Lordship, affect the eligibility of the private respondent number 7.
Why?
Because back to back, Lordship, that's not condition, Lordship. Though it's a part of the Form C, I agree that I can't dispute that. But the issue is, Lordship, the substantial requirement prescribed under the RFP, Lordship, whether that has been fulfilled or not. If that is not fulfilled, Lordship is aware, Lordship, every minor Lordship examination cannot be done, Lordship.
But you are supposed to do.
I was,
Not by the court, cannot be the
I
court.
agree that I was supposed to do, Lordship. But Lordship is, Lordship, aware, Lordship, this minor Lordship is always there, Lordship.
This minor would above fraud and will become a major.
And so for correctness of the Lordship, this document also, Lordship. This chartered accountant is not before us, Lordship.
You are at least before us.
Lordship,
Who has evaluated the tender?
Lordship.
You will be justified.
So my Lordship,
That's all.
no, I have.
So substantially, you are admitting that there are certain discrepancies or differences in the documents of the respondent number 7.
No, Lordship, I am not admitting what we stated in our affidavit, Lordship. We demanded Form A, we perused the Form A, and it was found to be correct. Then accordingly,
And you fail to appreciate the next page, 124, a certificate of the turnover certificate issued by the chartered accountant.
Lordship,
Because there's a difference. Huge difference. 172 and 176.
76 and 17,000 around.
but today, Lordship, while sitting, substantially, whether it satisfied Lordship 1.7.4 or not, that has to be seen by
You
the Honorable Court,
satisfy us,
Lordship.
you persuade us.
And if it satisfies the 1.7.4 Lordship,
I'm
requirement
not-
under one.
as of now, I've not been persuaded, I've not been
Like,
convinced.
Question is that, Lordship, why these documents were duly
Why
not
these documents
Well,
has not been properly
duly examined, Lordship? That's
Yes,
one issue, Lordship.
yes.
They should have been taken they should have been taken at that point of time, Lordship.
No,
Now-
we can examine it. These are the documents.
Now-
On which the respondent number 7 was awarded the contract.
We rely on the Form A, Lordship.
Huh?
We rely on the Form A, and Form A satisfy the Lordship
See,
1.7.4,
when you have prepared the documents,
Lordship.
treating it to be Form A, and thereafter you are submitting another documents, which shows that it's the certificate.
No.
Which one you have to? You have to examine both.
But we demanded, Lordship, Form A. We demanded Form A and we examined the Form A, Lordship.
Then what about this? It's a continuation of Form A only. It's a part of Form A only.
They have submitted, that's their Lordship, but
That you have ignored.
no.
You have not taken,
No,
taken consideration of this.
That is not the continuations of Form A, Lordship.
So you have not
Yes.
taken consideration of this 124.
Lordship, what we stated, Lordship. We, Lordship, demanded Form A and Form A found to be correct, Lordship, then we have awarded, Lordship. We rely that particular Form A.
So second documents you have not.
That's a Lordship. And that submission also may be noted as per CPW manual, Lordship. This turnover and this even the similar works, Lordship. For similar works, Lordship, 20%, more than 20%.
When you have stated in your affidavit. That has been explained in the affidavit.
Lordship, which one, Lordship?
That turnover and all those.
Lordship.
And then Form C.
Lordship, kindly see my reply to IA, Lordship.
Reply to that is bringing certain documents to the.
That is give reply to
IA, Lordship.
They are not pressing the IA.
They have relied the documents of the IA only, Lordship, mostly. Gray, Lordship,
Yes, where it is.
D and all, Lordship.
Affidavit.
Lordship,
Where reply. Objection. It's an objection.
Lordship,
Huh?
Lordship.
Objection or what?
Kindly come to internal page, internal page 6, Lordship. On top, Lordship will find total pages are 21.
I don't know. Reply. Affidavit by respondent number.
This is by respondent number 3, 4, 5, and 6.
Yes.
Kindly come to page 6, Lordship. On top, Lordship will find page 6 of 21, Lordship. Lordship, yes, I'll read from here. Lordship.
Hmm.
Without contraventions rules so and so, in a matter of financial property of G.
In internal page 6,
Page 6. Lord.
this is reply.
The reply, Lord.
Reply filed by the state respondent.
State response.
Yes. Page 6.
Page 6. On top, Lordship, Lordship will find.
However, without contravention. However,
Lordship.
however,
Yes. Correct.
yes.
I'll start from the Lordship down below, Lordship.
Hmm.
Sorry, yeah, this in absolute concurrence with the CBC guidelines through its manual for procurement of so and so issued by the minister so and so and so and so. In adherence to the statutory order by the government so and through its office memorandum number so and so, where it's emphasized the adherence of CPW manuals to have a uniform tendering procedure in the state of Orange and to examine the APPWD registered contractor from submitting eligibility documents like similar nature of works experience, tools and plans and technical stuff at par with the CPW Works Manual 2022 and standard operating procedure for CPW Works Manual 2022. All the engineering departments under state of Arunachal Pradesh who were involved in execution of civil construction works are directed to implement and comply with the provisions outlined in SOP number 4.8 and 4.9 of the standard operating procedure for CPW the Works Manual 2022, while inviting tenders and refer to Annexure 21 CPW 6 e-tendering of standard operating procedure for CPW Works Manual 2022 for details. Also clause 3.1.3 of CPW Works so and so and Annexure 6 of standard operating so and so to so and so may be referred for specialized work. This memo here, Lordship, we have said that Lordship, we have adopted Lordship, and this turnover and Lordship similar nature of works Lordship. Turnover is not required for Lordship APPWD registered contractor Lordship. That we have listed in our Lordship.
But then they have submitted the turnover.
Even then, they have submitted the turnover.
So you have accepted it.
Correct, Lordship.
And you have considered it.
Lordship.
And found to be above 158.
Correct.
Then what is the requirements of going into all this?
No, I'm just submitting this honorable for Lordship. Otherwise, also it's not required Lordship. Because this is very pertinent Lordship. Issue is
it is not required. What is the question of pertinent?
No.
See, suppose the respondent number 7 have submitted as required under 1.7.4.
Lordship.
And the Schedule C documents. You have considered and accepted, found to be responsive. Why we should go for do all these things?
Lordship. Then I'll place some judgment.
Yes. Just write the judgment, name of the judgment. Not some judgment. Only advice.
Only 4 judgments.
What is judgment? Yes.
1991 SCC 492.
91 SCC.
1999.
1999.
1 SCC.
492. 492. Yes. Then
Lordship. Next is Lordship 2020 16 SCC.
2020
16 SCC.
16 SCC.
489.
Afcons.
Silpi construction.
Silpi construction. Then
2022 6 SCC. 127.
127.
NG projections.
NG project. Yes.
Then Lordship 2023 SCC online. SC 671. Tata Motors Limited.
671. Tata Motors.
Tata Motors. This is a port citation, Lordship.
What does it say?
Here, Lordship, the First one is lordship, at the instant of lordship, the contractor who is not eligible lordship. The writ court will not lordship entertain lordship.
That will be totally misplaced
No.
because this is a case where the petitioner
Lordship,
was not eligible to participate.
lordship.
This is the present case is a person, though eligible, he has not fulfilled the condition of the contract. I mean, the NIT.
No,
Here's
here,
the difference.
here Lord participated, then rejected lordship.
Because he was not eligible to participate.
No.
But here, the petitioner has eligible to participate. There's a difference.
Lordship.
Anyway, let's proceed.
4 citation, I think.
Yes, next is 2020, 16.
Silpi. It's a 1991 is Ronak International lawsuit.
Then there are, in that case, 40, 5 cases you are citing.
I am citing lawsuit 1, 2, 3, 4 cases lawsuit.
1999, 1 SCC.
Yes, lawsuit.
That is Ronak International.
That's Ronak International lawsuit.
Then 2020, 16,
Yes,
Silpi.
lawsuit.
Huh?
Lawsuit.
Then
2022,
Hmm.
6 SCC, 127,
Hmm.
NG projects lawsuit.
Hmm.
Then 2023, SCC online,
Tata
SC,
Motors.
Tata Motors,
Ah,
671.
so what does it say?
May I lawsuit, take lawsuit to the citation?
No, you just tell.
This,
It is the author of the documents. The interpretation of the author of the documents has to be given deference.
lawsuit. Here, what? Here also lawsuit, in 2023 lawsuit. He also participated lawsuit. Only only the relaxation given to one and not the other one lawsuit. Yeah, whenever court, just I'll read lawsuit, then this only judgment I'll like to read lawsuit.
How long it is?
It's I'll not take much time.
I have to hear the respondent number 7 also.
7 lawsuit submitted yesterday lawsuit. Will take only 15 to 20 minutes.
No, 15 minutes you're running short of that.
And
Roads are being constructed.
yes, lawsuit.
Works is going on.
Going on lawsuit.
Full swing.
Yes, 27% has been already.
Only 27%.
Documents are there. Before tendering, works were done.
No, I'm coming. May I place one more text lawsuit before I start this
Which one?
citation lawsuit? This is lawsuit this flagship program under the PM Divine lawsuit, and this is very important project connecting the lawsuit for Seoul Railway of our state to Seoul Airport lawsuit, and it was lawsuit foundation was led by President of India lawsuit.
That's why you have not installed the project. The
And that part
constructor-
lawsuit, Bhumi Pujan was done by Prime Minister personally when he visited to inaugurate the airport lawsuit. Then
It's okay.
may I proceed with
We'll
the
hear the set.
Citation?
You submit the citation.
Okay.
You give the citation. All right.
lawsuit? Just
No, this is on the point of what?
on this
On
point,
what
lawsuit.
point?
At the instant of lawsuit, see, the contractor who is not competent lawsuit, who is not eligible lawsuit,
I'll examine.
participated
I'll
lawsuit,
examine.
Okay.
I'll tell you.
and that apart lawsuit, and 2020-16 interpretations of the close lawsuit. The author is the lawsuit, the right person to lawsuit. So
Due deference has to be given to the interpretation of the author of the documents. Due deference has to be given.
Lawsuit.
Hmm.
2020 lawsuit. So that's
And that the AFCONs and Marco Polo might have been relied in those cases.
lawsuit. Many judgments have been
AFCONs
relied.
and infrastructure. Justice.
In this 2023 SEC online lawsuit, many judgments have been relied on in Tata Motors. And lawsuit, this minute examination.
That's why I'm not letting you read out.
microscopic examination and all those have been lost.
Yes.
That's all lost.
May it please your lordship, my lord.
Yes, Dekha.
My lord.
Well, it's your own risk. Make your submission.
Yes, my lord.
And
I am aware, my lord.
and lawsuit, the present status lawsuit, that is lawsuit already, I'm submitting.
Yes. What is that?
The present status of the work.
It's going on full swing.
Yes, yes.
37% completed. 27.
Yes.
27.
27%.
So how many months are left?
It's there also. This is S on 24 lawsuit, this 24. Yes.
So when we get that also. How many kilometers?
31.
31 kilometers.
Close.
Yes. Yes.
My lord. My lord will kindly come to page 33, my lord,
Hmm.
of the writ petition.
Yes.
Because the first issue is whether the petitioner himself is eligible or not, my lord.
Yes.
Because the contention of the petitioner is twofold, my lord. One is that even if he does not meet the requirement of 158, having turnover of 158, he is eligible because he has to be assigned marks under Schedule D.
Yes.
Am I clear, my lord? So, lordship will kindly come to page 33. It is clause 1.2 of the RFP.
Yes.
It says the project shall be implemented, executed in EPC mode in two bid systems. The first is, my lord, technical cum eligibility bid. So, a vital provision of the tender, my lord, has not been read, my lord. At page 37, clause 2.6, whose financial bid will be eligible, my lord? Lordship will kindly take it up, my lord. Page 37. Employer has adopted a two-stage, two-bid system.
Yes.
Referred to the bidding process. Lordship kindly takes up page 37.
Yes.
This will answer the query, the first question, my lord. Employer has adopted a two-stage, two-bid system referred to as the bidding process for selection of the bidder for participation in the financial bid. Under this process, the bids shall be invited under two stages, my lord. Eligibility and qualification. So 1.7.2 and 1.7.4, my lord, it is qualification. Sorry, my lord, eligibility. And Schedule D is the qualification. Of the bidder, technical bid will be opened and examined as scheduled in RFP based on the details submitted under first stage with respect to eligibility and qualifications criteria prescribed in the RFP document. Last sentence, my lord. The financial bid under the second stage for only those bidders whose technical bids are responsive to eligibility and qualification requirements are met as per TOR shall be opened called in due course. So therefore, my lord, he has to be eligible as well as he has to qualify. Now, eligibility conditions, my lord, it has been read over and over again. I am not going back, my lord. The clause is absolutely clear, my lord. In my respectful submission, no interpretation is required. The clause is the bidder should have had average annual financial turnover. It does not say that the bidder should have had a turnover in any of the years. It says the bidder should have average annual financial turnover of not less than so and so on any works during the last available 5 years.
Yes.
My submission is, my lord, further fortified by even Schedule D, my lord, where it says that in addition to fulfillment of requirements, my respectful submission is that you have to first fulfill the eligibility criteria. Then you move on to the technical evaluation. When you are qualified in both, only then your financial bid will be opened.
Yes.
Now, my lord, another vital aspect of the matter is page 41, my lord.
Yes.
How it is to be evaluated, the financial bid. Page 41, my lord. This is in terms of the SOP of the CPWD, my lord. Kindly come to point number 4, my lord. The last 5 years, how it has to be evaluated, my lord. Every year, the financial turnover for the year 2018-19 has to be multiplied by 1.26. Of 2019-20 has to be multiplied by 1.21. Similarly, 2021 has to be multiplied by 1.14, 21-22 by 1.07. Why this has been done, my lord? This will be evident from the affidavit of the state, my lord, in the IA, page 28. Lordship may kindly make a note. This has to be cross-referenced to page 28 of the reply in the IA.
Yes.
Here, I'm just reading the part, Lordship will kindly note at page 28 of the reply. The value of annual turnover figures shall be brought to the current value by enhancing the actual turnover figures by simple rate of 7% per annum, my lord.
Yes.
So this is the factor they have calculated, my lord. I have made a calculation. I request my learned colleague, Mr. Taba, my lord. I have prepared a chart. I have prepared the chart. In the affidavit also the chart is given. How the calculation is to be made, my lord.
It's okay.
Why I have given the chart, my lord? That I am meeting the criteria of 158, my lord. And even going by this calculation, the petitioner does not meet, my lord. And that the petitioner admits in the IA. In the
Yes,
IA,
next.
my lord, in the IA at page 10, my lord, the petitioner is admitting that it has to be enhanced, my lord.
Yes.
So regarding the contention of the petitioner that there is no clause in the tender which allows the tender committee to reject the bid for non-fulfillment of the eligibility criteria, my lord, that is not correct. I have shown clause 2.6. Now, I'd like to, on this point, my lord, I'd like to place a judgment of the Supreme Court, my lord. 1976, my lord, 1 SCC, page 671. I'm not reading out the paragraphs, my lord. Just I'm pointing out. Paras 28, 30.
76, 1 SCC.
Yes.
1976, 1 SCC, page 671.
Yes. Para.
Para 28, 30, 34, 37, 38, and 39, my lord. As to who is a person aggrieved. In so far as
go into all this. It's
Lordship,
okay. Next,
record my
next.
submissions because that he is not
Next,
a person.
next.
He is not
Yes.
a person aggrieved.
Next.
So far as accepting my tender is concerned.
Next.
Now, my lord,
Yes.
coming to the form of the chartered accountant.
Yes.
Page 124. I cannot go back or say that there is no discrepancy, my lord. There is a discrepancy between 123 and 124. What my respectful submission is, my lord, when we take the figures in page 124, I am meeting the criteria. That calculation I have shown in my affidavit, my lord. By applying that multiplying factor 7%. Because even if today, my lord, lordship interferes and lordship sends it back, I cannot be disqualified on this ground. But the petitioner will be disqualified. So at the instance, because Ronak Engineering, my lord, Ronak case is clear absolutely. That here, there also, my lord, Ronak was the selected party. The ground was that.
It's okay. Don't go for that. Ronak International.
Yes, my lord. I'll be
Okay.
relying on para 8 of that.
Next, you just said that. Why there's a discrepancies? Why is there's a difference in the page 124 and 123?
I admit, my lord, there is a difference.
Yes.
But
Why?
my learned friend is alleging fraud, my lord.
Ah.
My lord, if I had any intention of playing fraud, my lord, I
See,
would have simply given
Page,
perform.
page 124 is a certificate of turnover certificate issued by
Yes.
the charter accountant.
Yes, my lord.
And page 123 is financial information prepared by you
Yes.
and certified by the charter accountant.
Yes, my lord.
Though it is written as Form A, in fact, the page 124 should be the
Exactly, my lord. I'm with your lordship.
Form A.
I'm with your lordships. My lord, there is no discrepancy so far as page 124 and the 125, etc.
Yes.
The figure is 176. What I am on is, my lord,
Yes.
that even if 176 is taken, I am eligible, my lord. I meet that criteria of 158. I have shown in para 26, lordship will kindly make a note, para 26 of my affidavit. The calculation which I have just now shown that it is,
Yes.
I am meeting the criteria.
So there's no justification of the difference.
I cannot
Why-
justify
why- it's your, you see, it's your documents.
Yes,
You
my
don't
lord.
have any justification.
My lord, it is apparent. Apparently, it is a mistake, my lord.
Okay.
Apparently, it is a mistake, my lord.
That's all.
Because I cannot, my lord, I cannot, because if I had what I am submitting, my lord, fraud is defined in section 17 of the Contract Act, my lord.
Let us not go into that much.
Because they are alleging fraud, my lord. If I had what I am submitting, if I had
Yes.
any intention of misleading the authorities, my lord,
Yes.
or getting the contract, I would not have annexed the turnover certificate.
Next, then
Then coming to that certificate of page 130, my lord.
yes,
The requirement is at page
53.
35, my lord. What is the requirement of the tender? Let us read it, my lord. I'll come to 130, my lord. Lordship will kindly come to 35.
Yes.
17.2.1. The bidder should have satisfactorily completed one work as mentioned below during the last 7 years ending previous day of last day of submission of tenders. So this, at page 130, if your lordship comes, I am meeting the criteria at page 1, point number 1. Now, coming back to the form at page 53. Whether the work is on back-to-back basis, madam. The submission made by my learned senior friend is that I have done it as a subcontractor. Madam, where is the bar? The clause does not say that if I have performed some work as a subcontractor, that experience will not be counted. Whether the work was done on back-to-back basis, my lord, my respectful submission, it has got no reasonable nexus with the object sought to be achieved. The object of asking for this is whether I have performed the work in the last 7 years. So therefore, even if there is a deviation, my lord, it is not a material deviation. It is substantial compliance of clause 1.7.2.1. There is no bar in the tender that if I have done a work through subcontract, I am not eligible. Had this been tender been the point number, column number 10 been that whether the work has been done on subcontract or not, then I could have understood, my lord.
Yes.
Now I'll also rely upon certain judgments, my lord.
Give the list of the judgment. You have the list of this. Just keep it.
My lord,
That's
Rona,
all. That's all.
that's all, but I'd
Do you
like,
have the list? Do you have the list of the judgment?
yes, my lord.
You just submit it. As I said, it should be, judgment will be reserved. Can you file written submission?
Lordship will give us at least 3-4 days time, my lord.
Yes.
By
Monday,
Monday,
by Monday you submit.
by Monday we'll file.
Yes.
Lordship, just one. Lordship, the citation 2023 Lordship, SEC. Here Lordship, kindly note the paragraph 47 to 54 Lordship.
You just give that list.
Okay.
List and the copy of the judgment.
Okay.
Because it's very difficult nowadays to carry these books.
Here, just to clarify one Lordship has made an observation, Lordship.
Yes.
There one, he was not eligible at all. Here, Lordship, the both party participated, Lordship. But one has been rejected, Lordship, non-responsive. Other one also not responsive, Lordship. In recent judgment, Lordship.
Yes.
Held in Lordship at the
Page. No,
paragraph 47 to 54 Lordship. And more pertinent is 49 Lordship. If Lordship permits, I just allow to read the 49.
It's okay.
Paragraph 49 only, Lordship.
You give me written submission.
Here, Lordship, it's
Heard Mr. PJ Sekiel, and the senior counsel, assisted by Mr. R.S. Mr. Land Counsel for the Police. And also heard Mr. Estafil Lalit, senior government advocate for respondent, state respondent number
Lordship, I'm for respondent 1 to 6.
1 to 6. Mr. Endeka and Mr. Endeka for respondent number 7. Respondent number 7.
My lord.
Judgment, hearing concluded, judgment reserved. The parties will list it, or will not list it?
No, we'll submit.
Will list the matter.
Lordship going to reject
Okay.
By Monday we'll
Judgment,
give, my lord, and thereafter Lordship will pass judgment. By Monday we'll give the written arguments. Thereafter Lordship may pass the judgment by anything.
hearing concluded, then we'll list it again on Monday.
No,
Hearing concluded, list the matter on 05.
for judgment.
No, not judgment. You'll have to, for written submission.
Okay.
Will not mention it.
Lordship may say that hearing is concluded and list on Monday for filing of written submissions, my lord. That will be better. Respect me.
Hearing concluded, list this matter on 05/08/2024 for submission of for filing of written submission.
Oblige me.
Yes, pass.
The discourse service upon respondent one still for.
Await service report list after 3 weeks. Yes. $15. What is to be done? Who appears?
Lordship, otherwise can.
You are appearing.
Yes.
Who is appearing for the?
Learned counsel D. Laji was appearing. Lordship. He is there. Hearing.
Petitioner to take steps.
No, yes. Your Lordship, the counsel for the petitioner had already withdrawn their name, Your Lordship. Now the notice was issued, Your Lordship. They have received, but they did not appear, the petitioner. Therefore, a amicus curiae was appointed, Your
Okay,
Lordship.
so for steps for respondent number 2, who has to take?
The registry in that case, Your Lordship.
Or Mr. D. Laji, learned counsel, learned amicus.
Amicus.
Amicus for amicus, learned amicus curiae. And also MST Gini learned simply for the state. Number 1. Registry to issue notice to the respondent number 2. This after 3 weeks.
Deeply.
Yes, sir.
Yes, my lord. My lord, in this case, I have gone through the contents of the report of the
Yes.
notice.
So
It is awaited.
yes.
But my lord, this case is pending since last 10 months.
It's okay.
We are in the same stage, my
Then,
lord.
then you take precious steps.
My lord, I would like to pray before your lordship
Yes.
to direct the OCPS to submit a report of causing service of notice.
No, you will have to issue it. This is offense under section.
376.
Yeah. No, you have taken the precious steps on. You have not taken precious steps.
No, I have taken mine.
When?
I don't remember the date, of course, I have taken.
Oh, yes, 1 month back only.
But my lord, Nahalagan
We'll
police
wait for
station is
some time.
not Pari, my lord.
We'll wait for some time. Office note reflects. Office note dated 29/7/24 reflects that service in respect of respondent is still awaited. List after 3
My lord, I have one IA also.
Huh?
One IA
We'll
also.
wait for the list along with this.
My
List
lord,
after 3
let
weeks.
this matter be hard today. IA.
376 will hear. Let the notice be served first. List after 3 weeks.
Okay, whether we'll wait for
Wait for
some time.
Yes.
No need to
Then
take.
thereafter we'll say we may send the notice through the PP. Thereafter we'll see.
All right. Obliged.
Yes.
If I may, my lord, we beg to take fresh steps in this matter, my lord.
Mr. G. Talo, learned counsel for the petitioner. Press for and granted 3 weeks. At 2 days time to take press steps.
Yes, my lord, finally, step has been taken up on the respondent number 2.
Yes.
I was directed to take the respondent number 2 and I able to locate that this respondent number 2 is Edita Nagar. And now my brother is accepting on behalf of the respondent number 2.
Yes.
This may be released after 1, 2.
Office note dated 15/6/24 reflects that the notice upon respondent number 2 return has returned back unserved. Has been received back unserved. However, Mr. C. Modi, learned counsel for the petitioner. No. Next page. However, Mr. G. Talo appears for the respondent number 2.
Yes, ma'am.
The list accordingly, Mr. C. Modi, learned counsel for the petitioner has produced the copy of the petition to Mr. G. Talo, learned counsel for the respondent. This is the matter after 3 weeks.
Much appreciated.
Wait,
Yes.
Lordship, we have just received a copy of the affidavit in opposition.
On the prayer of Mr. D. Lorna, learned counsel for the petitioner. This matter after 3 weeks. 2 weeks.
2 weeks, Lordship.
2 weeks.
For admission here.
So as to enable him to file affidavit in reply.
Yes, sir.
Affidavit in reply to the affidavit filed by the respondents. List this matter after 2 weeks for admission hearing. Huh?
Obliged, Lordship.
Yes.
Lordship, we have received affidavit in opposition.
You want to file reply?
We will file a rejoinder.
Yes.
Mr.
Mr.
D. Tali.
Learned counsel for the petitioner submits that he may be granted 2 weeks time to file affidavit in prayer the law. List this matter after 2 weeks.
Obliged, Lordship.
Not submits, huh? Has spread for 2 weeks' time to file affidavit in reply. Spread the law, list after 2 weeks. Yes, next.
My lord,
Yes,
my lord, I cannot take, could not take any steps for notice upon
Mr.
respondent.
So learned counsel for the petitioner
May allow to take
is allowed
fresh
2
steps.
days' time to take fresh steps.
All right, my lord.
Hmm. Same,
20, 22, 23, and 24, same.
same.
Yes, ma'am.
Yes. 22, 23, 24. Yes,
And in this case, respondent number 2 was initially not impleaded, and thereafter he was impleaded, and service of notice was taken upon him.
yes, you take,
Your
you
lordship.
find out the address and
No, Your Lordship, I'll just have a small submission, Your Lordship. The informant here is the chairperson of CWC, before whom the victim was rescued and kept under CWC Sonitpur, Your Lordship.
yes,
The victim need to be made a party, Your Lordship.
okay.
The informant has been made a party, Your Lordship.
Victim has to be made.
Yes, the address of though the victim is minor, her name can be not disclosed. It's at page number 51, the address of the victim, Your Lordship.
Then you file an appropriate application.
No,
for
this
it.
case is not related to POXO, and the complainant is also
Yes,
made a
but-
party herein. He was impleaded in this case, and we have also served the notice to him.
Your Lordship, if Your Lordship
whether
see
the
the
notice is
FIR, Your
complete or not.
Lordship. FIR has just been filed by the CWC, bringing to the police notice that a 12-year-old girl was rescued and was handed over to the CWC.
So forget about it, since the notice has been unserved, returned back on the ground of non-availability of the address, you find out the address and you see.
Yes.
MS so-and-so learned counsel for the petitioner to take fresh steps after assuring the proper address of the respondent number 2, list after 4 weeks. Well, why to go into all this controversy?
Because, Your Lordship, the victim, though it's not a POXO case, Your Lordship, victim, it was on the only information given by the informant. His role was that police has rescued so-and-so girls and has been kept in the CWC. That was only his information. But the main victim has to be made party. Deeply obliged.
This in the IA, here is the filing defect that will be allowed to be withdrawn.
So what is to be done? What is to be done?
There is filing defect, I will file fresh.
You want to withdraw?
There is no prayer for
Mr. Titapa, counsel for the petition, request for withdrawal of this IA. Within bracket criminal 68 of IA CRL bracket close 68 of 22. Praise the Lord. The IA stands close on withdrawal.
And I will file fresh.
The learned counsel may file withdrawal with a liberty to file a fresh. Huh?
Deeply obliged.
Yes. Yes. What?
Steps Steps.
Office note dated 18/06/24 reflects that the scanned copies of the case varies. Scanned copies of case record is received. This for admission after 3 weeks.
The February.
Yes. What is this?
My lord,
Modification.
yes, my lord.
Why not go for final hearing? Have you filed the affidavit?
No, my lord, I have filed IA, my lord, for vacation of.
Why it should be vacated?
My lord, because my lord, this, by interim order dated 10/4/2024, my lord, this court has directed not to implement seniority list, my lord. My lord, let them file, my lord, objection, my lord, and matter may be fixed on.
Yes.
8 of-
Privacy, you are for 5 to 13.
Yes,
Your appointment is divorce the rule.
my lord, in fact, my lord, their appointment is under cloud of investigation, my lord.
They are trying to remove the foundation
Their appointment is investigated by SIC and CBI.
equally.
Yes, my lord.
Okay. We'll see that.
We'll
Heard
file-
Mr.
My lord,
In IA, huh?
yes, my lord.
LBC, London
file
Council for the,
objection.
London Council for the applicant, respondent number,
Applicant 1 to 9,
huh?
applicant number 1 to 9, and
Applicants. This is an application for next para, huh? This is an application for modification, public vacation of the alteration of the order dated 10/04/2024, passed by this court in WPC number 166 April 2024. List of next para. Issue notice. Mr. Dilona appears for opposite party number 1 to
24.
24.
Yes, ma'am.
1 to 24 and oblique petitioner, huh? And MS A Wang move for respondent number 25 to 28 for state respondents. Come on. Since the opposite parties are duly represented by the London Council, no formal notice need be served. However, the police the parties, the opposite party, opposite parties writ petitioners may file their objection, if any. List this matter after.
My lord, on 8, my lord. 8 August.
8 August. Okay. List the matter on 8 August. The government has filed the affidavit in the writ petition.
No, Manoj.
You file it before 8. We'll consider. Yes, 35. Yes, despite order of this court granting pre-arrest bail, you are arrested. Now, what is the status?
Well, that order has been made absolute. Right,
So what remains? What you want from here?
Malud, petition has been filed on 2 court. One is Malud, on
violation of the order being filed by this court.
Yes.
Secondly, my lord, handcuffing of the petitioner. Which are, my lord, violation to the, my lord, citation and several judgment of this court. My lord, in this case, basically we have paid for compensation. Among the this 5 days. What violation of the, my lord, fundamental rights of the petitioner. Because 21 as well as 19 of the petitioner's rights has been violated.
So far as the violation is concerned, you have the remedy. It's gone now. Right? We cannot turn the clock back. So far as the violation at that point of time. Now bail has been made absolute, you are out on bail. Still you are, what is the stage of the case?
Oh, it is statute only. But file is okay.
Okay. So that we cannot do anything. You forget about that. So far as handcuffing is concerned, unless we establish that you have been illegally and without a requirement to be done, the compensation cannot be just awarded like that. Because wrongly, rightly, you were arrested. That's what I'm saying. And well, after arresting, what is the offense?
Offense is 354.
350.
354, 323, and 506 IPC.
Okay.
Already.
Yes, you are.
This court was in the IA, filed by this accused, has held that there is a lapse on the part of IO. So there is more court in the dispute.
Prime facie.
Probation.
You were hearing it finally. You establish it.
We find this FIR complaint date page number 70. Here, interim bail is granted by the parole court is 8 page number 50. So there. I've heard both sides in the methods of prayer for interim relief, page number 19. Considering the materials available with the record, this court is the opinion that the petitioner deserves to be given interim relief. Accordingly, as an interim measure, it is hereby directed that in connection with Itanagar Women's case number such as the petitioner, namely Sri Venkatapam, release on bail on punishing of bailable of rupees 10,000 with a surety of like amount to the satisfaction of the arresting authority. Petitioner Venkatapam is directed to appear before the investigating officer within 7 days from today. This order was passed only on 8th of February 2021. I was directed to appear within 7 days. But within 7 days, just on next date, I appeared before the I. One will find an exception. But for this IO, the case, he refused to accept bail order. Citing that, I have not deposited the bail amount into the account of CGM UPI. So, accordingly, again on next page, I again appear before the IA. This is on 10 February 2021. And except for page number 21.
Yes. Yes.
But As part of day, I was arrested on same day. Arrest memo, following fine, in excess of 5, page number 13. Column number 5.
Yes.
Date, time, and place of arrest, 10/02/2021. Thereafter, my lord, accordingly, this annex of C. Page number, annex of 6, page number 23. I was handcuffed by the IO. For 2 days, my lord, I was kept in remand.
Police remand,
Here,
police custody.
here. On 10, my lord, I was arrested. On 11, my lord, I was produced before the London CGM UPR. Which is Lecture 8, page number 25. Accordingly, my lord, I was forwarded to judicial prison. Right order dated 11/02/2021, Lecture 9, page number 28. So, my lord, being agreed with the action of this IOMA, I filed one IA in the pending and substitute bail application, which is at Lecture 10, page number 30. All we find is para 3 more. It is very imperative.
Yes.
Malo. Please to tell this para 7, page number 32.
30.
32. Page number 7. Oh, para 7, page number 30. Conversation or observation. At this stage, I have no doubt that the investigating officer did not comply with the direction of this court. It is evident from his letter dated 12/02/2021 that says the applicant did not cooperate with the investigating officer.
Yes.
Follow. Thereafter, follow this series of application were submitted. Follow. Since the state hearing, here also follow, like it is 11 for the act of the IO. Therefore, this petition is filed. Even Malo is whenever that petition is old one. In the case of Abbas Al-Jarid, which is reported in 2023 SSC online. Well, I just have the soft copy only. Hard copy I have.
Why you are not having a hard copy?
Therefore, Malo, for placing all those authority, Malo, next and make communities.
Get it print out. Do that option.
It is there.
Print it.
Well, let's also, all of this, one authority of apex code.
How many judgment?
2, 3 or more there.
Huh?
2, 3 or more there.
2 or 3?
3 altogether. Malo, we find this, para 3 more. Page number 5.
What does it mean? What does it say?
This says for
If you-
compensation model,
Is where it is?
the para number 3 model,
Huh?
page number 5. Last paragraph.
Yes.
Paragraph 10.
Hmm? Para 10. Hmm.
Parameters of global completely support my question.
Hmm? How many days you are there?
I was arrested on 10th and I was released on my own. Over 2 days.
2 days.
2 days.
Kilometer. Item 12. Yes.
Lordship, order passed by the server court. Directly, he was granted the interim bail also. On condition that on satisfactions of the arresting authority. He appeared before the lordship IO also, on 10th also, on 10 itself also.
Yes.
Interrogation was done lordship. Then he was asked to lordship produce the surety and with the bail amount also.
Yes. Yes.
Which lordship they have not lost. They have not just a valid ID of accused actual estate of bail was sought by the investigating officer, who is the brother-in-law of alleged failed to provide. Even after such suggestion, no deposit slip or I believe ID was produced before the officer in charge to the investigating officer. So that is the lawsuit, how the condition was imposed by the Supreme Court only lawsuit, because it is in the satisfactions of the arresting authority lawsuit. Then we sought for these documents and bail amount lawsuit, which was not lawsuit fulfilled lawsuit. On next day,
In IA, it is something else. You have explained, IO has explained that in spite of the previous bail order, the investigation on the ground that he had failed to provide the information sought by the IO.
no, that's another aspect lawsuit. There's another aspect. May I read lawsuit then other part lawsuit, the paragraph 4 lawsuit.
Requested the London Government for filing appropriate application cancel of the interim ban.
That is lawsuit. Non-comprehension of in interrogation, this another aspect lawsuit.
No, on that ground only. Now you are trying to develop your case. IO is trying to say that and they have said that you have refused to accept that. It was deposited before the CGM. And the counterfoil was sound to you. You refused to accept
Lawsuit, that we have denied lawsuit. And lawsuit, had it been a true lawsuit, on next day lawsuit, the CGM would not have lawsuit remanded him lawsuit. From next day lawsuit, on the basis of the order passed by the CGM lawsuit, he was in the jail lawsuit. Had it been available lawsuit?
No, before that you have said since he's not cooperating, he's not revealing any information. Therefore, you file an application for cancellation of the bail.
Lawsuit.
IO has said so. It's all recorded by this court.
IAS lawsuit statement is before us lawsuit in
Page 2, the order of 2/12/2021. And what is the order of IO? IA, order in IA?
Well, that is on
Order of this court in IA. Page
number 31.
31. Since the applicant did not cooperate with the investigating officer, he was arrested. Page 32.
Page 32 lawsuit, paragraph 5 lawsuit, may also read lawsuit. Here, the objecting to the prayer made by the applicant, MS so and so has submitted that pursuant to the order of this court, the applicant failed to furnish bail bond to the investigating officer. That is why he was arrested. MS so and so submitted that the court directed the applicant shall be released on bail on furnishing a bail bond of rupees so and so with surety of like amount to satisfaction of the investigating officer.
That is the submission. The finding is page 7, para 7.
At this stage, I have doubt that the investigating officer did not comply with the direction of this court.
It is evident from his letter that 12/02/2021 that since the applicant did not cooperate he was arrested. Where is that letter?
Only doubt has been expressed also.
No. After that, it is evident.
12/2/2021.
Letter. That is also recorded by the order in this. And the I was directed to appear in person. She appeared and 3/12/2021, she was directed to file, she was granted to time to file affidavit and apology for further consideration. But then you have filed affidavit in opposition against the respondent, in the petition, in the petition. Since you have tendered your apology, you are directed to file an affidavit of apology, not to counter the present petition.
Lordship, I am appearing for respondent 1 to 3, Lordship.
Yes. Who is respondent number 4?
4 is the IO, Lordship. By
Yes.
name, she has been implicated.
She is the main party.
But the records is at Lordship, GD entry. GD entry, Lordship, is at page 8 of my affidavit, Lordship. Here, Lordship, everything, the development is basically used to be written down in the GD, Lordship.
Who appears for the respondent number 4?
Mr. I think Bori was, Uttam Bori was appearing, Lordship. Lordship, my only one submission, Lordship, as I submitted, Lordship. On next day, Lordship, he was remanded by the CGM, Lordship.
Doesn't matter. First of all, you have the respondent number 4 has violated the court's order. That we cannot do. By violating, he is arrested and then he was handcuffed.
He was remanded by the CGM, Lordship, from that. And
Think
parents can
about
be,
the compensation, quantum.
and parents can be
You
drawn.
go through the records. It is all recorded by this court.
Actually, I was,
See, when it was on the basis of the communication,
no, sir.
12/02/2021. The communication reflects that he was not cooperating. He wants some, the IO wants some information. Therefore, he was arrested.
No, sir.
And it was handcuffed. And personal appearance was directed. He appeared and she tendered her apology. And the court has directed her to file an affidavit of apology for further consideration. Thereafter, he filed a counter affidavit to the petition, which was not granted. You may file, 1, 2, 3 may file. So far as the violation is concerned, it is, I mean, we may have a lenient view, but handcuffing and all this cannot be permitted. So we'll take it up on
Another date.
Tuesday. You go through this.
Actually, earlier I was
Tentatively will direct it for compensation.
I'm sorry, Lordship. Earlier I was not here in this case, Lordship. So I am not aware about all this.
So only for order disposal, we were fixing it on Tuesday, next Tuesday. 5/7. All right.
Lord, I may be allowed to submit one citation one.
Whatever you want to. Her Mr.
G. Rebound.
G. Riva, learned counsel for the petition, and also her Mr. MS. Mr. S. Tafit, learned senior government book for respondent 1, 2, and 3. Non-appears for respondent number 4. You inform Mr. Bori.
Hello, Alan. You said next.
Heard in part. List this matter for further hearing on 06/08/2024.
Okay.
You may come up with the quantum of compensation.
No, sir.
Yes. What? That has been already over. Why?
Already facing the trial like teacher without any difficulty.
Heard Mr. Then, whoever, in fact, adjournment. They heard Mr. D. learned legal aid counsel, amicus curiae, 4. Amicus curiae, and also MSTG in Islamics, additional people. Next paragraph, Mr. Learned amicus curiae submits that he has an instruction to withdraw this transfer petition. Therefore, he prays that matter may be closed. Mr. Next one. The consider the prayer of the next prayer. The prayer of the learned amicus curiae is accepted. Accordingly, the transfer petition is instance dismissed on withdrawal. Item 15, huh?
This matter will be listed tomorrow.
Why?
Yes, no.
Tomorrow we have so many matters.
In the meantime, I will take the instruction and then it will possible, I may withdraw. For that purpose only. Just now I have a.
Don't take that discord is a little too harsh. It's not a harsh, because we'll have to see that thing. No? We'll have the best on the, we'll have to decide and dispose of based on the knowledge of the court and the lawyer. Right? Because I find nothing.
I have also gone through the.
Because by your own showing only. Then on the prayer of Mr. Existing learned counsel to the petitioner, list this matter on 31/07/2024. So as to enable him to obtain instruction as to whether the petitioner wish to pursue the matter or not. Mr. Creding. Who? In the morning, it was mentioned, this court has refused. We have nearly 1 hour. We can hear the matter. Yes, Modi, you can.
Madam, I have not got the record, so.
You could have gone through, it's the last case. What is the matter?
I got it. It is regarding the length.
Yes.
Where the state officer has it's the edition of it.
Yes.
The land is a private land.
Hmm.
So the question was initiated under public uses.
Hmm.
May I please, Your Lordship?
Yes.
Your Lordship, this land belongs to the state government, Your Lordship. It is evident from the annexures given in annexure 2, annexure 7 and 8, and annexure 9, annexure 11, and annexure 14, Your Lordship, whereby the Department of Industry was allotted the plot of land which is under the dispute now.
Yes. This is, where do you get it? Your affidavit?
Yes, Your Lordship. Affidavit by the respondent number 3. May I please, Your Lordship? In paragraph 21. Affidavit by the respondent number 3 in paragraph 21, Your Lordship.
21.
Yes, paragraph 21. Para 21.
Of what? Your affidavit?
Yes, affidavit in opposition filed by the respondent number 3.
3, yes.
Yes. May I read, Your Lordship?
Affidavit, respondent 1 and 4.
This is for respondent number 3, Your Lordship. By the DC. Yes, Deputy Commissioner Upper Siang. Who has also passed the impugned order, which is under challenge, Your Lordship.
Okay. Respondent number 3, yes.
Yes. Paragraph 21. May I read, Your Lordship? The answering deponent begs to state that the petitioner is wrong and denied. Series of correspondence took place with the industry department for fixation and releasing the land revenue amount, which had been referred in above paras and in project attached. Annexure 2. Your Lordship, Annexure 2 is in page number. Annexure 2 is in page number 37, Your Lordship, where the plot number, 4,456 square meter was, it is not evident in this order, but this order, in the last paragraph, it is written that in the meantime, you are once again requested to initiate necessary action for obtaining sanction for payment of the land dues, which means that this land is already allotted to them, Your Lordship. The allotment order is in. Allotment order is in Annexure 3, Your Lordship. Approval for allotment of land to the state central government departments and income, and which has been typed out in the page number 42, Your Lordship. State government department, serial number 2, industries department, Your Lordship. We're concerning about the industries department. Plot number 2, 13, 15, Your Lordship, total amounting to 4,456, Your Lordship. Residential, non-residential, residential building. Yeah. It has been allotted to
What is
the.
the area of the total area of the land claimed by the petitioner?
450, around 450 square meter.
It's very clear.
My lord, please.
Nothing doing.
My lord, in the case number 67 of my lord, petition, my lord.
On what it said, it has been, this has been allotted to the Department of Industry, right?
No, my.
And the land claimed by falls within the type 3 quarter.
No, my.
Premises of type 3 quarter. That will believe, and if you have any dispute that it's a private land, you file it, you may file a title suit, not a writ petition.
My lord, they have passed the eviction order.
Yes, this will allow to, you'll be, you file a title suit, file injunction or whatever stay in the appropriate court.
There is a survey verification.
Not Monday.
Survey report is also there, Your Lordship.
Tomorrow. But we're not adjourning it. It's a government land. These are the tactics adopted by the people. We cannot blame the lawyer. No, we are not believe. We don't believe.
Gamburas, they are not.
We are not. We cannot
They
believe.
cannot wait it.
The respondent number 3, Deputy Commissioner,
Yes, sir.
on what said that it's a government land. We'll get by that. If you are disputing that it's a private land, you file a title suit.
Yes, because I am supposed to file, but they initiate a proceeding under public use and pass the.
So till that is decided, we presume that it's a government land because the government quarters are there. So you'll have to give way. If you get the decree from the court, you'll get everything back.
In this area, not only my land.
So since as on today, it is a premises of quarter type 3 quarter of the industry department, you'll have to go.
My lord, in this area, there is so many private land.
Doesn't matter.
My lord,
That will be also done. That will be taken care by them, not by you.
because this land is my private land.
You file a petition, the suit before the appropriate court. Heard. What is to be?
Because my lord, I am not the
What is to be heard tomorrow? There is nothing.
because my lord, I am not the leading.
Doesn't matter. You are equally a competent lawyer. Huh?
Even I am not one for the one comes.
Better you ask
They-
your client to withdraw the writ petition. And immediately file a suit if you think that it's your private land. Then
May,
ask for
may, Your Lordship.
injunction, yes.
This morning I was not ready, but I was,
Now you are ready.
yes, now I'm ready, then they have vanished, Your Lordship. This is not fair. Because they were there this morning. I was not ready.
Some emergency, but leading counsel.
What is
What
it?
if-
Why do we need a leading counsel here? You are equally a leading counsel. Yes, you are not less than any other leading counsel. You are equally competent.
In appeal order also, his name, his name is reflected. Your
Yes.
Lordship. He's been doing the case, Your Lordship.
So you do it in trial court, not here. You take instruction to your client, come back tomorrow, better withdraw so that you can. Otherwise, if we pass on dispose on merit, it may have some bearing also. Tomorrow, the trial court may not have that kind of. So think over it. But whoever comes, whoever appears, will be dismissed or allowed to be withdrawn.
I have the instruction.
You take instruction from client. Nothing will improve. Either you or anybody else.
On similar case from last occasion, this has allowed me to withdraw the petition and given a petition.
With similar matter.
Petition number 51 of 22.
You bring that, we'll see. By this court.
Yes.
In fact, if it's the power of authority and power of the trial court, we should not assert on it. In fact, maybe leniently dismiss him. You bring that also. In any case, I've seen it, not now. I've seen it yesterday. I've read it yesterday. That's why I thought it will be wastage of, just adjourning the matter unnecessary. That's why time was not granted. It was by them, by the government. So while fixing it, or order tomorrow, either dismiss or allow you to withdraw. No further hearing. No further hearing, no adjournment, nothing, only for orders. And I know if Titi Tara appears, he may take another 10 minutes. But I'll hear, I don't have to hear him. I have heard you enough, that's all. All right. Heard Mr. O. Modi, learned counsel for the petitioner, and also heard MS
P. Sangeeta.
P. Sangeeta. Then State Council. List this matter for order tomorrow, for order.
For instruction from my client. Whether she want me to or not.
No, I had this, no, this matter on 31/01/07/2024. For further instruction to be placed by the petitioner. And so as to enable the learned counsel by the petitioner to obtain instruction with regard to the withdrawal of the writ petition. If no instruction is if no instruction is obtained, the matter shall be disposed of by passing appropriate orders tomorrow. In any case.
Offline.